Good morning. Welcome to the hearing for the inquiry into the Crimes Sentencing Procedure Amendment Good Character Sentencing Bill 2026. I acknowledge the Gadigal people of the Eora Nation and the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name's Sue Higginson and I am the Deputy Chair of the committee and acting in this role until Mr Borzak joins us today. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants, and I encourage committee members and witnesses to be mindful of these procedures. I also advise and warn that the subject matter of this hearing may involve information of a sensitive nature. I now welcome witnesses in our first panel for the day. Thank you for making time to give evidence. Could each witness, starting with you, Mr Fraser, please state your name, your position title, and swear either an oath or an affirmation?
Yes, thank you. My name is Scott Fraser. I'm a public defender and I wish to take an affirmation. So I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And Mr Terracini.
My name's Alexander Terracini. I'm a public defender. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And would either of you like to make a short opening statement?
Not from me. I note that there was a submission filed on behalf of the public defenders that we rely on as our position.
I agree.
Thank you. Right, we're just going to have some questions from the committee members. We'll time those questions. We'll have sort of 10 minutes from the crossbench, 10 minutes from the government, 10 minutes from the opposition, but we will also free flow with those questions as well. Ms Boyd, would you like to start?
Thank you very much, Chair. Thank you very much for coming this morning and for giving us the benefit of your expertise. I wanted to go directly to the issue of child sexual assault offenders, and sort of if we could not include the other bits just for, I know that the bill does, but if we could just focus on that particular reform. Looking at your position and your, I guess, support for including good character, none of them appear to really apply in the circumstances of a child sexual assault offender. So, for instance, in paragraph 14, you say, good character may support a finding that the offence was an isolated lapse representing human frailty. We know that's not the case with child sexual assault offenders. There's more to every person than the single worst mistake they've made in 16. Again, we know that's not relevant to child sexual assault offenders. So in the case of child sexual assault offenders in particular, what is your argument for allowing a good character reference to be made?
Well, our position is that the law as it applies presently is such that the courts very often, if not always, give very little weight to good character in those circumstances in any event. The position we've taken is that to the extent that there is High Court authority that says that good character should nonetheless continue to have some sort of weight in those proceedings, we don't oppose, in fact, support a change that would permit the court to disregard entirely in that situation.
So given that, it, as you say, it's, it would seem pretty irrelevant in most cases, yes. I'm really struggling to think of a case where it could be at all relevant, given that child sexual assault is something that happens behind closed doors, yes. Ordinarily. It's something that most people would view as being out of character with the person that they know.
Yes.
If there's really no real circumstances we can think of where it would be relevant, why would you allow it to be put forward, not just re-traumatising victims, but also really acting against that message that child sexual assault can happen at the hands of anybody, regardless of how good you think they are?
Yes. I mean, I think the position would be that, well, firstly, if it can be said, that there are degrees in terms of the severity of child sexual abuse cases. That's not to suggest any is not serious, but some are much more prolonged, much more significantly courses of conduct over periods of time
That you know of. I mean, that's...
Well, in terms of what I see, in terms of what I
Yes.
see, and in terms of what the courts are dealing with, there are instances where the courts are dealing with what is a one or twice off instance, and there are others, obviously, which are over many years and many generations. I guess the point really is that the courts presently are, particularly in that type of matter, and especially where there is a course of conduct, are regularly saying that they are giving no weight to good character that is relied upon in that instance.
So, I guess, sorry, just one last question for a hand to my colleague. So if we get to the point where it's not really used anyway, and again, this is where we say, well, on balance, perhaps it would be better to not re-traumatise victims and actually to send that strong message to the community that no matter how good you think a person is, they may actually be an abuser and you should be talking to your kids. Given that balance, the campaign that kicked all of this off was called, you're referencing, Relevant. How is it really relevant to a person's culpability or to the punishment they should receive, what other people think of them outside of the context of the situation in which they abused a child?
Well, as I say, often it is taken by the courts of having very little, if any, relevance because it is so overbalanced by the course of conduct that is the offending that has to be sentenced. The type of evidence that's often led in that situation may still have some relevance or some bearing in respect of prospects of rehabilitation, likelihood of reoffending further down the track, or ability to engage with treatment and so forth. Often, though, the courts are saying when the course of conduct is so long and extensive, or the type of offending is so heinous, that it, even in those circumstances, has little weight at all. But blanket disallowing the evidence disallows for a situation where there may well be some relevance to the particular sentencing exercise. And our concern is that individualised justice requires that the offender at least is able to provide what they can to the court so the court can understand them and consider that in context of the offending. We're not suggesting that the re-traumatisation of victims is not real. We acknowledge that it is, and it's a concern, but it's something that we think that perhaps by using better terminology, perhaps by judicial education in terms of how these matters are approached by the bench in decisions that are handed down, so that it is clear when a victim is in court or on screen listening to a judgment that they understand the way in which it was taken into account or not.
Thank you. I've just got two questions. I might give them to you at the outset, and if you could take them and answer them in order. But one is, you've submitted that evidence pertaining to someone's character may interact with other mitigating factors, such as duress and provocation. If you could you give some examples of some of the circumstances in which this may be the case? And then the second question I'm going to ask, which is quite different, is The Sentencing Council's dissenting report stated that a fundamental change, such as a complete removal of this principle, is likely to result in extensive litigation over many years and in many unintended and foreseen consequences. And I'm just curious about how you think that litigation may play out, the likelihood of that, and the impacts that may have on delaying justice. So they're two very different questions. If you could start with the first, please, about provocation, duress, and so forth.
Did you want to?
In terms of provocation and duress, obviously the relevant test requires that there to be subjective aspects of the person's character, which could therefore play into hands. For example, if there was a vulnerable domestic violence-related female that had been part of an appalling marriage for an extended period of time, and after 20 years of otherwise crime-free life, she had snapped and done something criminally wrong, this bill, if passed, would deny her the opportunity, firstly, to defend herself properly, and then, if she was convicted, it would deny her of that previous experience. That is why the aspect of provocation and duress was drafted by the public defenders, because the bill, as it's currently expressed, is all-encompassing when sentences and the notion of good character in the courthouse is not. It's individual.
And just on that point, can I just ask, and is it in your experience, particularly in the case of perhaps that circumstance that you just portrayed, it may well be that a particular woman may actually have a history of not a clean record, as we refer to, or a history of some sort of offending, because it is not necessarily, the perfect clean record female victim that has been subjected to domestic violence will come before the court. Is that the case?
Yes, but there's a whole gambit of people that come before. So
In our submission, or in our letter to the council, we draw attention to a case of Martin, which was a young female who, in fact, had been subjected to domestic violence, had been subjected to domestic violence on the day that she offended. And ultimately, when before the Court of Criminal Appeal, that court was of the view that her character was very relevant in circumstances where ultimately there was an element of provocation or that was enlivened in light of the domestic violence circumstances. And so that's an important consideration, because too, when we're talking about concern about re-traumatising victims, she in fact was herself a victim survivor and it was the fact that she was a victim survivor that was a contributing factor in her reaction, leading to her one-off aberration offence. And that's the concern we have when one blanket removes this a mitigating factor, that it affects not just a particular targeted situation where it ought not be considered, but it also affects those where it should properly be considered in their favour on sentence, such as Ms Martin and others that would be like her. In terms of the second question, if I can address that, the second question, without rewriting sentencing law completely, which would mean removing certain purposes of sentencing, such as rehabilitating a person, so prospects of rehabilitation are relevant, likelihood of reoffending is relevant, and so forth. The bill, even as it is presently presented, does allow for some what has been called good character evidence to be admitted for other purposes. And the difficulty that we foresee, and we understand was being spoken of in the dissenting view is that there may be instances where a judge is not allowing evidence where it was relevant to another topic, or it may be a situation where a judge is not giving sufficient weight because despite it being relevant to another topic. It also could be the case that a party or the person representing an offender may not introduce evidence thinking it's not relevant to a particular topic, and then later when that person seeks advice on an appeal, it is determined that perhaps there was evidence that should have been put before the court that wasn't put before the court. And there's a minefield of potential appeal avenues that arise through that, and in particular as to how the evidence that might not be admitted in or admissible in one context could have and should have been admitted in another context, and how it might have been given weight by the court.
Thank you. And now I think we allocated the 10-10, so I think it was...
Thanks, Chair. Thanks to you both for coming along, much appreciated. My first question is, assuming that the bill is passed, and I note that it's not proposed to change the law so that, for example, an account of a person's history is not going to be relevant to prospects of offending or prospects of rehabilitation, those things will still be relevant. How will this practically change the handing up of material, including statements from third parties about what they know of a person? Do you think there'll be any change to the language used in terms of reference or anything like that? How do you think it'll practically work in the court system? And I ask the question because in terms of the threshold of admissibility, I would have thought that everything that is admissible now will likely be admissible under the regime. It'll then be for the judge to unpick in quite a potentially complicated exercise what part of it's relevant only to character and what part of it is relevant perhaps to prospects of rehabilitation, prospects of offending, etc. So could you talk us through how you see this practically working in terms of the evidence that lawyers are tendering?
The references, perhaps we won't call them character references anymore, but the references will still be handed up. But to address the specific links that the bill would then require us to join, they would need to be perhaps more specific to the offences. The generic, I've known him for 30 years, he's a nice bloke, he wouldn't have done these things, he's very sorry, frankly should never really have been tendered in the first place, regardless of the bill, because what weight do you place on that anyhow? However, under or progressing, it would need to be far more offence targeting. So, for example, if you were playing, rugby with somebody, they'd been involved in a number of squabbles on a football field, they've never reacted with violence, they've always been the pacifist on the football field, but then in the pub fight, this one time they actually aren't the pacifist, then there would be a practical example with a pattern of behaviour that a local court, judge now, a local court judge or magistrate, or district court judge could appropriately link that to another purpose of sentence that isn't simply just character.
Yeah, and that's why I was curious. Why do you say it wouldn't be called a character reference anymore?
To make it abundantly clear to the decision maker, try and make it easier for them, that the advocate is in effect handing up a reference that isn't on character.
Except couldn't a person's prior good character, as spoken to in a document, be directly relevant, depending on the other evidence, to prospects of rehabilitation or offending?
100%.
I mean, I'll just give you this scenario. Say you've got a case where a person does a particularly brave act, acting with complete reckless disregard to their own safety.
Yes.
that would be considered an act of good character, but the person's got a lengthy criminal record speaking to reckless behaviour, in those circumstances, that prior history is probably not going to speak to good character for them in a positive sense, because everything that they've done that might be considered sort of merit-worthy from a societal point of view is clearly a product of underlying factors that are actually dangerous to the community.
Yeah.
So you have that situation. But in a different situation where someone's, say, got no criminal record, wouldn't their good character in those circumstances actually be relevant to prospects of rehabilitation or prospects of offending, even though it can't be taken into account only because of that?
Without a doubt.
Yeah. So couldn't you still tender a good character reference, in effect, named and titled as such? Or not? What do you think?
Well, the title doesn't matter as so much as the substance in the reference. But
Well, except
yes.
that isn't there an issue here about trauma and so forth, and people
Yes.
not wanting to hear someone who's offended against them described as a person of good
Yes,
character?
That's right.
Yeah,
And,
so I just want to tease out how it's going to practically work.
and there needs to be some education, either through the decision makers themselves in how they address this aspect of sentence, but also through the Crown and the DPP in how they, and the witness support officers that are designated social workers on behalf of the DPP that are there for victims, that they're appropriately preparing the victim for the sentencing exercise. I mean, sentences in general are difficult for victims because it's no longer about them and it's about the perpetrator.
Yeah.
That's the point of the sentence. And there needs to be greater emphasis on explaining those issues and that dynamic to victims outside the court, rather than simply just having them in the room and then them hearing these aspects of the perpetrator's life for the first time.
Yeah.
That, in our view, is unacceptable.
So just going to you, Mr. Fraser, on all of this, do you agree that this reform, it's not a reform of evidence law, as I understand it. It's a reform of sentencing law.
Yes.
So I'm interested in your thoughts on how this will practically affect the admission of evidence, and particularly, do you agree that good character as a factual proposition will under this reform still be relevant and admissible insofar as it speaks to prospects of rehabilitation, prospects of offending?
I think the short answer is almost certainly, if not most times, then if not all times, then most times that is right.
Yeah.
And that then, of course, highlights a difficulty with the bill, is that the bill isn't, in fact, or potentially isn't achieving one of its primary objectives. If the objective is that the courts, the re-traumatisation comes from the courts receiving and considering evidence of good character, if it is going before the court in any event, then the bill hasn't achieved its objective. And that's where what Mr. Cerrucini says is something that I would endorse, which is that education, and particularly judicial education, in terms of how judgments are written and prepared, and how a judgment is supposed to explain not only to the offender but to the public the reasons for the decision made by the judge, including on an important aspect like this, why and how character is taken into account. But I agree with your point that from a defence lawyer's perspective, what it may be that a reference no longer has good character or character reference as its heading, but the content of it is unlikely to change, provided...
So why wouldn't it have that heading anymore if the bill was passed?
Well,
We just talked before.
so that we're not waving a red flag to the judicial bull, so to speak.
Except isn't it important for this reason, that if people approach this reform on the basis that good character evidence is no longer admissible,
Yes.
then isn't there the potential for a series of miscarriages of justice? Because if the bill is passed, good character will still be relevant and admissible, insofar as it speaks to one of those other considerations.
Yes.
So wouldn't it actually be quite concerning if lawyers and judges adopted that approach, because it risks at the threshold of entry into evidence
Yes.
a sort of unlawful restriction on evidence?
And that's the concern that was highlighted in the dissenting judgment in terms of the potential for further litigation, appeals, and so forth, because it then puts practitioners in a position of what is admissible, what should we be relying upon, and judicial officers in a position of what was admissible, what is allowed to be relied upon, and the potential for mistakes to be made in that process, for relevant evidence not to be before the court, or irrelevant evidence to be considered in an improper way, is great once you start restricting the nature of the evidence in that way.
Yeah, so do you think it would be advisable to give some statutory guidance if the bill is passed, so that it's clear that good character evidence is not inadmissible, it just has to be relevant to one of those other objectives or relevant considerations, which is, for example, prospects of rehabilitation and offending? Would it be a helpful thing to have some clear guidance in the bill about that?
I definitely think that's so. I mean, the bill does, as I read it, whilst declaring such evidence inadmissible, does have that proviso that if it's admissible for another purpose, it is then admissible. But as I say, we come back to if the evidence is in and the concern, and a significant concern and a real concern, is about re-traumatisation, then education and the way in which this is presented and spoken about is, in terms of addressing that issue, that's the way forward as we see it, rather than this reform, because this reform is not only getting to that very difficult situation where character really shouldn't have much role to play at all, but it's affecting so many other persons who ought to be able to call upon it, who have their one-off indiscretion.
Thanks, Jim.
You've probably already dealt with this, and I agree with most of what you've put. One of the chief contentions is that the use of the expression "good character" re-traumatises victims who have experienced trauma as a result of some heinous act being done by someone. How do you deal with that as a notion?
Yes. Firstly, as a notion, I completely understand it. Particularly a victim of systemic abuse over time, a child victim, but not even restricted to then have it said in court that this person is somebody of good character. I can totally understand how that would have the effect of shocking and likely re-traumatising the victim. That's where Mr. Terracini was referring to the prospect of using a different language in order to describe these things, and again with judicial education, that a judicial officer not refer to this type of evidence in a different way, so it's not using a very jarring expression such as the person having good character. It's their capacity to otherwise be law-abiding, their capacity to perhaps engage with treatment and so forth. That's where the evidence is relevant without needing it to be called good character and having that blunting, traumatising effect.
Well, we already do in some cases where a person, for example, has used their position for the purposes of facilitating them committing the offence. Already, we do limit the ability to call good character evidence in relation to that person.
Yes.
Yes.
Are there any other circumstances you would suggest where it could be used?
Well, that's an instance where the mitigating factor, statutory mitigating factor, simply cannot apply, where a special rule applies, where there has been, or where the good character has been used in order to facilitate the offending behaviour. The proposal that we, from the dissenting chapter that we adopt or endorse, is one whereby the courts should be given a position of regarding and making clear it is regarded that type of evidence is completely irrelevant in the appropriate case where it is just.
It's the no weight argument.
That's
Yes.
right.
Yeah.
The difficulty becomes if if one places a blanket rule. There's good reason for the blanket rule in the special provision that is there presently where it's used to facilitate the offence. Once it becomes a blanket rule otherwise, the difficulty is that cases in terms of severity will be on a sliding scale, and the difficulty we see is that although there will be clear cases where no weight should be given, there will be other cases where some weight ought to be given, and if the evidence is inadmissible, then it's inadmissible in both those situations, and that's the difficulty.
So is it your position that all you do is create a situation where you will create more litigation by virtue of the fact that material which should have been before a judge wasn't allowed to be before a judge?
That's certainly the fear.
Yes.
One of the arguments which has been put in relation to why this is important is that character evidence is often the province of the wealthy and well-heeled and people who've... Is that your experience of the way good character evidence is facilitated before courts?
No.
Give me some examples.
It's difficult to actually give you some examples from my own matters, but it is not good character or character in general is not only or is not intrinsically linked to privilege. Sure, there are the classic examples that garner media attention, but frankly, the concern of the defenders would be the underprivileged person that would be impacted by the passing of this bill, who is not privileged in any way, but would not be able to go before a court with the history of being underprivileged and be able to talk to the judge and say, well, this is my prior good character despite the history that I've been.
So it's a bit of a myth, is it, to sort of say that...
It's not a myth, but it is not as black and white or as obvious as if you come from privilege, you have good character. That's just not a notion that is accepted in a courthouse.
But you might have access to people who can potentially, by their position in society, can potentially give weight to aspects of your character.
Well,
which
one has to have trust in the judicial officer to understand whether or not how much weight they place on those references.
Look, in my experience, if I can just answer it, is that the courts are more looking at the substance of any such reference rather than the author of the reference. And yes, sure, there are examples where people call in for references, prime ministers or celebrities or so forth, to attest to their good character. My experience is that the courts are looking at the substance, not the name, and so the average person who might hold down a trade but volunteers with their local football, coaching for their local junior football team on the weekend, does other beneficial things to the community, is generally helpful to in their neighbourhood. That's attracting equally, and if not more weight, than a name on a piece of paper that might have after it former Prime Minister or so forth. And I'm only using that as an example, but and it really demonstrates that it does cover the breadth, and it's the evidence that goes to what the person has shown in terms of their their true character and through what they or how they otherwise conduct themselves day to day. And as we've said, the difficulty with the blanket bill as it is presently is that for many offenders who will offend once in their life, it might be that deaths in family or alike meant that they had too many drinks and got into a fight on the weekend or drove home when they shouldn't have on the weekend. They can't call into support of their otherwise good character over the rest of their life.
Let me put this position to you. We've had lots of representations about individual cases, and individual cases obviously give rise to their own difficulties.
Yes.
But someone comes along and I'm a victim of domestic violence. My partner is a war hero, and potentially decorated war hero, but my circumstances at home are just shocking, where he comes home and regularly I'm the subject of domestic violence. Can you understand the position of that victim of domestic violence in a court where evidence relating to the perpetrator's history of service in the armed forces and their potential heroic acts in other places are used for the purposes of trying to demonstrate their good character, and that person is saying, how does that help me at home relating to what I'm experiencing in that domestic violence situation? Why should that history of their good character or their service overseas be relevant to what's occurring at home in my circumstances?
In that example, and I'm assuming it's an example where there is some history of this type of violence that's been perpetrated within the home, the experience says that the courts are giving that, seeing that as attracting little, if any, weight on the sentencing in the sentence hearing. The difficulty.
Do we have any way of measuring whether that's true or not?
We only by reference to what. And the difficulties, we have to then go to individual cases, but only by reference to how the judge will communicate that in the reasons on sentence as to how it has been considered and how no judge is going to give I've given this a 5% weight as opposed to a 95% weight or anything like that, but there ought to be within the reasons a clear indication of whether the judge has taken it into consideration and if so, how.
Thank you very much for coming today. We've come to the end of your period of questioning.
Thank you.
Were there any questions on notice?
No, I don't think anything.
There weren't any?
No.
Okay, thanks very much for coming.
Right, thank you.
Thank you. No, we'll just keep this. No, you don't.
Crossbench opposition government this time.
Okay, all right, thank you. Thanks very much for coming. Could each of you please give us your full name, position, title, and swear either an oath or an affirmation, starting with you, Ms. Saunders.
My name is Jane Sanders. I'm here in my capacity as the chair of the Criminal Law Committee at the Law Society of New South Wales. and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Tooney.
My name's Dominic Toomey. I'm here in my capacity as President of the New South Wales Bar Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And Mr Broadbent.
Good morning, my name is Nicholas Broadbent. I'm here in my capacity as a bar counsellor. I am also a Deputy Senior Public Defender in New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Okay, thank you. Let's commence question. Yeah.
Thank you.
Did want to make an opening statement? Want to do 10?
Oh,
10,
yeah.
10.
Do any?
If it's convenient to the committee, I did wish to make an opening statement. And
Oh, sorry, you want to do an opening
for it.
statement?
If it's
Sorry, beg your
convenient,
pardon. Yeah.
and I think Ms Sanders may then wish to
We'll do the
supplement
10, 10,
anything I say or
based
may
on the
not.
objections of the government.
Firstly, I'd like to thank the committee for the invitation to appear today. The New South Wales Bar Association opposes the Crimes Sentencing Procedure Amendment Bill of 2026. We oppose the bill because an offender's otherwise good character continues to be an important consideration at sentencing. Currently, the sentencing process involves an assessment of both the offending itself and the offender as a whole person, including any evidence of their otherwise good character. This assessment is key to ensuring fairness and individualised justice in the sentencing process for offenders from all backgrounds and from all walks of life. The bill, in our view, would unreasonably limit the ability of the sentencing court to understand the offender as a whole person. Sentencing is undoubtedly a complex process. It requires careful consideration of a range of matters, including any aggravating and mitigating factors. Whether the offence is an aberration to a person who has otherwise made positive contributions to the community is and should remain an important consideration when a court is determining what is a just and appropriate sentence. That said, it is not our position that an offender's otherwise good character should, in every matter, lead to a reduction in sentence. The law rightly excludes good character as a mitigating factor where it was of assistance to the offender in the commission of a child sexual offence. Further, we would support a legislative amendment that makes clear that a court can, after consideration of any evidence of otherwise good character, assign no weight to this evidence when assessing that evidence against the objective seriousness of the offence. We note that this legislative amendment was recommended by the New South Wales Sentencing Council if it were decided that good character should be retained as a mitigating factor at sentencing, the position for which we advocate. Our members understand all too well that the sentencing process will often be traumatic for victims of crime. And for a victim of crime, hearing about an offender's otherwise good character can be seen as an attempt by a well-connected offender to minimise the harm they have caused. Recognising the harm caused to victims is and must continue to be an essential component of sentencing proceedings. Finally, we wish to address what is said to be one of the key rationales for these proposed reforms, that not all offenders are able to access potential mitigation at sentence based upon their otherwise good character. This was referred to in the New South Wales Sentencing Council's report as a so-called privilege discount for well-connected or well-resourced offenders. This is, we acknowledge, a concern which warrants some consideration, but it is important not to overstate its significance. we have heard from our members, including from Mr. Broadbent, who is here to my left today, that every day in courts across the state, offenders from disadvantaged backgrounds rely on evidence of good character at sentencing. It can and does support disadvantaged people where appropriate to mitigate the harshness of sentencing. The solution, therefore, in our view, to any potential so-called privilege discount is not to abolish good character at sentencing entirely, but rather to ensure that it operates in a fair and equitable manner. We can achieve this by ensuring that those from disadvantaged backgrounds are able to access the legal support they need, including by significantly boosting government investment in critical services like Legal Aid New South Wales and the Aboriginal Legal Service. We welcome the opportunity to explore these issues with the committee in more detail today.
And Ms Sanders. Thank you very much, Mr. Toomey.
Thank you. As Mr. Toomey has given a succinct but I would say comprehensive opening statement, I don't have anything further to add from the Law Society's point of view. We are in agreement with the bar on almost everything. I think save that the Law Society acknowledges that the concept or the word good character may certainly be traumatising to victims or to members of the community. We are open to exploring whether there can be a new form of words used, which is perhaps less traumatising. However, the term character, far from being a nebulous concept, as I think is suggested in the Sentencing Council's report, character, it may be a broad concept, but it is well understood by the law and the courts. So we wouldn't want to be lightly doing away with that concept. But certainly the Law Society would be open to a change in language if that was thought to ameliorate some of the distress to victims. But I'll leave it there for now.
Thank you very much. Can I just start, Ms Sanders, with to you about children, young people, so children and young people, how you think this proposed change could impact on how young people would be dealt with in terms of their character before a court?
I think in terms of children, I suppose when we're talking about quite young children, most of them probably haven't had a chance to, certainly not that they don't have character or personality, but maybe they haven't had a chance to build up a life full of achievements and contributions, perhaps in the traditional way that we speak of character for adults. But certainly I've worked with, and for those members of the committee who are not aware, in my day job I run the Shopfront Youth Legal Centre, so we work with homeless and disadvantaged children and young adults. My experience is a lot of the young people that I appear for, particularly young adults, we can point to a number of factors that go to their good character. They may be, for example, a young Aboriginal person or a young person from a refugee or migrant background who is doing an enormous amount for their family. It could be looking after younger siblings. It could be interpreting for their parents. It could be caring for elderly and sick relatives. It could be providing a role model for other young people in their community. And those are all things that speak to good character, not privilege, but good character, positive contributions to their communities. So I think it's certainly is something that can apply to children and young people. That sort of evidence, admittedly, of course, if good character is abolished as a separate consideration, that kind of evidence can be taken into account as to rehabilitation prospects. But our view is it is still something, a standalone consideration that should be able to be considered.
Thank you. Can I just also ask, do you in your practice become aware at all of, so if somebody has committed an offence, they're at the sentencing part of the process. This is, say, a victimless crime. This is somebody who, or whether it's a personal drug offence or something of the likes. Or if there is a victim involved, this is not related to a violent or an assault. Is there a role where the individual, by going and talking to members of their community to ask them to support them through the provision of a reference, is there a component of restorative justice that takes place at that point, or an account, perhaps not restorative, an accountability mechanism that anyone could speak to?
That's a good question. Do you mind if I take this question?
Sure.
That's a very good question, and I think, yes, there could be. Restorative justice, of course, traditionally involves an offender in some sort of conferencing process with the victim of their crime, or possibly a representative from a victims' organisation. So for offences without direct victims, such as traffic offences, for example, there could be somebody from a road safety organisation there to speak about the impact on road users, road trauma survivors, etc. So what we're talking about here is not quite restorative justice, but also some sort of accountability. If you are a young person, or really a person of any age, who has committed an offence, and you are going to ask a community member or your boss or someone related to you in some way for a reference, you are going to have to tell them about the crime. And a lot of people do manage to go through court perhaps under the radar, particularly in local courts where it's very busy. Thousands of cases are processed every week or even every day. And it is quite possible for somebody to just go under the radar without their family or their employer or their wider community knowing what they've done. If you are actually asking for a reference or a support letter, whether it be from your counsellor, your boss, members of your community, you are going to have to own up to what you've done. The best and the most useful references or support letters are ones where the writer can say, I am aware of the charge before the court. Melissa has approached me, she has discussed it with me. She's deeply remorseful for her action. She was embarrassed to disclose it to me, but she has, and notwithstanding that, I can say whatever. So yes, I think that can be a process of taking accountability separate from the actual court proceedings.
I would only add to that references in those circumstances will only have any weight if the person providing the reference also says that the offending was out of character for that person. If they believe that person to be prone to commit such offences in any event, whether or not they've previously been convicted of such an offence, then of course it has no weight at all. And I think I can say that our universal experience at this table is that unless the person providing the character evidence in that case has been made aware of the nature and indeed the detail of the offending, then courts simply put it to one side.
So you see, though, that there would be a loss in that step in the so-called justice system that's been operating for a long time, that would no longer be present for a massive amount of the people who are pleading guilty before the courts every day in New South Wales.
Yes.
I think there would be, and could I add that even if this bill is passed as drafted and as intended, of course the bill will still protect that kind of evidence about a person's personal attributes, contributions, etc. It will still allow that kind of evidence to be admitted for the purpose of other factors on sentencing, such as remorse, rehabilitation, etc. However, I foresee that in busy local courts, which it must be remembered deal with over 90% of criminal proceedings in New South Wales, the superior courts are only a fraction. Busy local courts, magistrates, now judges, since last Saturday, local court judges, busy lists, very high percentage of unrepresented defendants. I don't know, have up-to-date stats, but a few years ago it was running at about 50% of defendants in local courts were unrepresented. People who might be represented by legal practitioners who don't practice full-time in crime. I fear that there will also be, it will widely be disseminated, perhaps incorrectly, that courts can't receive character references anymore, which may strictly be true, but they can still receive this kind of evidence in another way. And I foresee that perhaps people will stop seeking and providing this kind of evidence in an erroneous belief that it can't be accepted at all. Sometimes busy local court judges, and I hope not, but let's be real, I think might say, character, this is not relevant, I'm not reading this, and they won't go through the exercise of considering how it may be relevant to other purposes of sentencing. So I'm worried, particularly if this bill is not accompanied by really good judicial and education for the legal profession and the public, that something will really be lost.
Thank you. Ms Boyd.
Thank you. Sorry, just in the interest of time, I'm going to be a little bit quick. In the opening statements and in your evidence so far, we've been talking about whether or not someone's offence is an aberration or out of character, and whether or not they're prone to commit the offence. When we're talking about child sexual assault in particular, if you are giving character about a person, you're necessarily giving character about their behaviour outside of the context in which they would be assaulting a child. Unlike, for example, if there's if someone's been accused of stealing and they come to me and say, look, can you give me a character reference? I can say, look, I've never seen them do anything dishonest. That's relevant to that offence. But if someone came to me and said, I have been accused of abusing a child, can you give me a good character reference? I mean, obviously I wouldn't, but I think the reason would be, if nothing else, I don't know what you're like behind closed doors. And I know that is one of the reasons that so many children get abused, because people present as being good in every other context. So I guess the question to you is, do you see that in the context of child sexual assault, that we might be dealing with something a bit different when we're talking about good character, and whether or not a person, their offence is an aberration or out of context?
Well, I think that is the rationale for Section 21, capital A, 5, capital A. That's what has already been recognised, and that is already baked into the provision. And that amendment was something that was supported both by the Bar and by the Law Society.
Sorry, they're slightly different though, if I could. So you're talking about where it says, if you've used your position. So I think a lot of advocates for child sexual assault justice would say every abuser has used their good character in order to get access to a child. So, or they were of such bad character that no one's going to give them a good character reference anyway. So in those circumstances, if it's never relevant, why are we still allowing that opportunity for that evidence to come in?
If I could attend to that aspect. So as far back as cases such as Ryan, Justice Kirby in that case referred to the circumstances where the objective seriousness of the offence and other countervailing aspects militated against the use of good character in any particular way, that would not be something that would be appropriately taken into account by the court. So we'd submit that that's already well and truly built into the existing common law, insofar as where the circumstances of the offence, such as, for instance, a child sexual assault, where one might have real doubts about where matters may have taken place behind closed doors. Often in agreed statement of facts, we have a situation where there's an indication that the offending is not isolated. In those circumstances, the common law is amply clear it has been repeated in cases such as Ghent as well, that it is not appropriate for a court to take those matters into account. Where the difficulty arises is, well, where is the line? We're clear about what the common law says about this, but the risk that this bill poses is that if there is an attempt to set some bright line, it removes the power of judges and courts to impose individualised justice. That is, that where there is an appropriate case for those matters to be taken into account, that it should be. But our submission is that under the existing common law, it is well established that there are types of offences and categories of offences where it may not be appropriate to take it into account. But that is not to say that that should apply in every case. That there's a risk here that in essence, a bill of this nature throws out good character in the appropriate case where indeed it should be taken into account.
Thank you. I'm out of time.
Thank you. Okay, so I think we said opposition next and then over to the government.
Well,
Thank you.
I just think, just following from what the question was Ms. Boyd was just asking, is that some of the other submissions seem to be suggesting that there may be cohorts of offences where this bill provides a blanket removal of good character. Another alternative position is potentially to identify cohorts of serious offences, where they child sex offences or serious domestic violence offences, which may be categories of offences which would be subject to the exclusion of good character evidence. Now, Mr. Broadbent, I understand the position that you take is that the whole of person should be a consideration, and in relation to the objective seriousness of the offence, no weight would be given to good character evidence, but it should be available anyway because courts should have before them the whole picture of the person for the purposes of sentencing. In terms of re-traumatising victims, though, do you accept that there is a position that in relation to the objective seriousness of the offences, the propensity to re-traumatise victims is heightened in those circumstances, and they potentially should be cohorts of offences that should be excluded because of that possibility of re-traumatising victims?
I think that the starting assumption needs to be treated with some care, and that is that the presentation of a subjective case for an offender is not and should not be treated as an exercise in sympathy.
Yep.
The purpose of the presentation of a subjective case for an offender is, as I've previously said, to ensure that there's an exercise of individualised justice. I was the public defender in Dubbo for 6 years, in the previous 6 years, and saw time and time again examples of people coming to court, victims, families of victims, who struggled with the process of sentencing. But can I say that, for my part, where the primary issues arose was not necessarily the use of the language, it wasn't necessarily the way in which the sentencing process proceeded, because good, competent lawyers always ensure that it's only relevant material which is put before the court. Where the difficulty comes is a lack of understanding about why something is being put forward. It's not being put forward as an exercise, as I say, in sympathy for an individual. That plays no part in a process of individualised justice. Where better outcomes were secured, I certainly saw dealing with very serious offences in regional areas, often with small communities, people with limited formal education, was when time was taken to explain to those victims and to their families what the purposes of sentencing were and what the evidence was being used for. When that happened, almost uniformly I can say the results appeared to be better. Now, I'm sitting on the other side of the bar table as a defender, so I'm not speaking to these people directly, but I was dealing with people in the same community. I knew who the various assistance services were, and when it was dealt with well, much of that re-traumatisation was, in my view and from my perception, able to be ameliorated, certainly at a surface level. So from my perspective, there's a real element here of education, which is necessary and advisable in the context of this. That would have the effect of ensuring that courts can continue to apply an individualised approach to justice, but at the same time ensuring that victims of crime are appropriately heard, just as they are when they deliver victims' impact statements and the like. So there's an education aspect to it.
No, I think that's an excellent explanation. Ms Sanders, one of the things that you suggest is that probably, and I don't know if Mr Broadbent would necessarily agree with this, but you changing the language, instead of using expressions like good character, you potentially hand up a, quote, prospects of rehabilitation report. Is that, if you were turning your mind to a change in language, what would that look like?
Yes, well, prospects of rehabilitation is a separate factor in sentencing, separate mitigating factor under 21A, that the offender has good prospects of rehabilitation.
But good character, mate.
But good character, if that were to be reconceptualised, I would think of something along the lines of perhaps personal attributes or contributions, contributions to the community. I mean, obviously, this sort of language would have to be really tested to see if that didn't have unintended consequences. One problem with Section 21A is that it is so binary. You've got your aggravating factors and your mitigating factors, and binary, it doesn't always work as an approach. If it was not expressed in such binary language as in some other jurisdictions, but it was a list of factors to consider, then it could be more neutral. It could be something like the person's personal attributes, character, contributions to the community, and that's perhaps not as jarring as asserting that a person is or was of good character. But getting back to the question about reports addressing rehabilitation prospects, I think very, very rarely in my career as a defence lawyer over decades have I actually handed up something that could truly be said to be a character reference. Mostly the reports I hand up on behalf of the young people I work with are, they could be reports from professionals. They could be support letters. I would characterise them more as support letters and character references. So they are talking about the person, warts and all. They're not necessarily suggesting that this is out of character because she's been caught shoplifting before. But it is putting the offence in context. It is talking about the positive attributes of this person. That yes, although she has a propensity to steal from shops, this is against a background of poverty where she is also trying to raise 2 children as a single mum, and she was just trying to steal some Christmas wrapping for their presents, which is actually a client that I saw yesterday. So yes, I think that it's perhaps a myth, or it's overstated the use to which character references are put in court. I think sentencing is usually a lot more nuanced than just coming up with a few references from well-connected people saying, oh, look, this is a person of good character.
One of the things, I take it you've read it, of most of the other submissions, but one thing that could is that it could create a circumstances where there is inconsistency in if this law was to pass it currently, is inconsistency between the application of sentencing relating to Commonwealth offences and New South Wales-based offences. Yes. Do you make any observation in relation to that?
Well, there already is. For example, hardship to family in Commonwealth law, that's permissible. In state law, it's got to be exceptional hardship to family. There are a few, don't even get me started on community safety and intensive correction orders, but there are a few anomalies between state and Commonwealth law we don't really want to add to them.
Yeah. And is that your view too, Mr. Broadbent?
I think the concern is at all times that once things become too prescriptive in trying to deal with a concept that is, as Ms Sanders said, as broad as good character, invariably what will happen is that you will single out and remove those outlying cases where in fact good character may be very important but is very difficult to adduce because of the overly prescriptive nature of the legislation. So if I can give you an example of that, in a regional community, for instance, an older woman who is providing a substantial amount of care for perhaps her grandchildren in circumstances where perhaps the parents of those children have their own difficulties either with drugs or the criminal justice system and the like, often in First Nations communities. The way that good character might be adduced is, I would submit, very important in a case of that nature, because it is of a kind where this person is providing a community positive thing. An overly prescriptive approach runs the risk of removing that as a mitigating factor in sentencing, which in my submission is against the interests of that individual and against the interests of that community. Again, the overly prescriptive approach, I would submit, removes the individualised nature of the justice.
So is it just the position, I take it, of or essential position that if you were going to make any amendment, it would be to I suppose, spell out that no weight should be available for the purposes of that evidence, of good character evidence in dealing with individual cases?
That's our position. That is our position. Some read Section 21A in its current form as requiring weight to be given.
And that because of Ryan.
Yeah. 21A requires it to be taken into account. We would be happy for it to be made clear that in the appropriate case, that having taken it into account, no weight can be given to it. And there will, I might add, be many such cases because good character evidence can never be taken to overwhelm the objective seriousness of the offence.
Stephen, can I just ask one little question? Sorry, thank you. I'm really curious about the difference between objective and subjective factors in good character, because in the examples you've given, like the fact that a person is a carer, or the fact that even the fact that a person is contributing to the community in some way, that's quite different to a subjective statement of, I think this person's a good person. Where's the line? Because I thought this was really trying to go to that, we're trying to exclude those subjective references, not the provision of evidence that goes to all of those objective personal circumstances.
I think herein lies the risk, because good character evidence is so much more than simply a statement on a letter to, I think this person's a good person. The way that this bill is drafted removes the consideration of any of these matters, broader or otherwise, because the nature of good character, as we say, is an umbrella concept, that it's a broad one. It's not simply a matter of an opinion of a person in the community as to that person's underlying attributes. I would submit that an opinion of that nature is the kind of good character evidence which is going to hold, in any event, the least weight with a judge. The evidence of good character which goes to community positive contributions is material which is highly relevant, we'd submit, to the sentencing process, but which this bill has the effect of removing.
Thanks, Chair. Thanks to you all for coming along, much appreciated. Mr. Broadbent, do you think that it's important for the operation of the theory of general deterrence that the community, insofar as they might become aware of a particular sentencing exercise, that the community is aware where it's the applicable circumstance that a person is of prior good character?
From the perspective of general deterrence?
Yes. Like, do you think it's important, for example, when someone's reading a newspaper article about a person who's being sentenced, do you think it's relevant for the operation of this theory that the community actually knows that this person is a person with a history of good deeds, the person hasn't been in trouble before, etc., etc.? Is that actually relevant to the operation of general deterrence? Because there could be wrongful assumptions in the community, for example, that good people or people of prior good character don't commit criminal offences, when I'm sure you'd agree they do.
That's certainly correct. And many offences contemplate, the law contemplates a circumstance where offences are committed by people in the ordinary course of things. So things like drink driving, for instance, things like low-level frauds, matters of that nature. Often the fact of good character is a matter which, in those cases where it's something which is commonly committed, can carry with it a somewhat lower weight in the assessment of objective seriousness. But again, from the perspective of general deterrence, drink driving is perhaps a good example of that. It's an offence which is committed. The experience is almost certainly uniformly at this table that drink driving offences are committed by all members of the community that is far broader than other offences. From that perspective, if it's put before a sentencing court that person is a person of good character, but that person is nonetheless punished appropriately, because invariably it is not. The law mandates that the objective seriousness of the offence is the consideration and a primary consideration in the sentencing exercise. Then that's going to have a positive impact on general deterrence, I'd suggest.
So to Ms Sanders, do you think that this bill, the provisions in the bill, do you think they're intended to operate as a rule of admissibility or admission into evidence? I know the rules of evidence don't apply on sentence, but do you think it's intended to bar the admission or reception of particular evidence? Or do you think it's more about the consideration of the material by the judge and what ultimately is given weight?
I don't think it's intended to bar the admission or reception of certain evidence, more how it can be taken into account. However, I believe an unintended consequence may be that certain evidence is not received, either by a judge who perhaps has an erroneous approach, it's not even tendered by an unrepresented defendant or by a legal representative perhaps who thinks our character references are out and doesn't see that it could be admitted another way.
Yeah.
So I don't think it's intended to prevent admission of particular evidence, but that might be the consequence.
Yeah. I mean, it would seem to me, for example, if you're a judge starting a sentencing exercise, and obviously evidence is adduced at the beginning generally of a sentencing exercise, and you get a document entitled Good Character Reference, it would seem to me pretty difficult to conceive of circumstances where you would reject that document on that basis, because you're going to need to hear submissions about the purposes of sentencing, the principles of sentencing. Such a document might end up being quite relevant to an assessment of risk, prospects of rehabilitation, etc. Would you agree with that?
I would agree.
Yeah. Mr. Toomey, just a question for you. One of the criticisms of the current law expressed by the Sentencing Council was that it creates some system of moral accounting where a person gets a mitigation on sentence because of extraneous prior good acts, and that sort of moral accounting in their sort of view is not a legitimate part of the criminal law. And I'm just wondering if you agree with that, or do you see circumstances where it might be artificial to not engage in moral accounting? I'm thinking, for example, of Mr. Tudorhope talked about this, but let's say a war veteran with a history of particularly distinguished service in recent times returns to Australia, maybe they're a national hero because of it, they're in trouble, and they're in trouble in a circumstance where the evidence really isn't looking too good in terms of risk, and that could be on account of war service even. So it would be difficult for the defence lawyer to rely upon their history of bravery or recklessness to advance a positive case. Should such a person in such a case have some mitigation on account of such valorous service to the country, or is that a form of illegitimate moral accounting?
Moral accounting is a somewhat emotive term. I mean, the High Court has made plain that the sentencing process is one of instinctive synthesis, and it's not. One cannot readily place evidence of prior good character or community mindedness or community contributions into what might be called a moral accounting category. I mean, one can always take an extreme case. Let's take another one. For example, let's take the person who has worked as a surf lifesaver for 5 decades, free of charge, has saved many people from drowning, and on a particular Saturday there's a drowning that they feel they might have been able to prevent and they didn't. They feel terrible about it. They go to the pub, they drink too much, they get in the car, they drive home, there's an accident. Most right-thinking people would say, particularly where that person's prior good character in those circumstances, that is, their enormous community contribution has some connection to the commission of the offence, that it would be artificial simply to say all you're doing is morally accounting. And this, I would repeat...
I suppose in that case, though, that's very linked into the circumstances of the offending, so it's going to get through the gateway and it's going to be considered in terms of a whole range of things. But, I mean, instinctive synthesis is more about the outcome, right? Like, instinctive synthesis is about, as I understand it, the sort of end process where you put all the legitimate things into the box and then you pull out the right outcome. But isn't this more about what considerations go into the mix? And I suppose what I was leading up to was, if you've got a case where a particular factual matter goes to prospects of rehabilitation, goes to prospects of offending, it's determined it has no other... it in those senses is not relevant to the sentencing exercise, and it's something about the person's prior good acts. Why should it bear on the sentencing exercise if it's not relevant to an assessment of risk, reoffending, prospects of rehabilitation? It's extraneous to the circumstances of the offending, so it's unlike the circumstance that you talked about. Why are those extraneous matters legitimate in the sentencing exercise?
Well, Mr. Broadbent is anxious to answer this question, so I think I'll allow him to.
If we accept that a significant element of sentencing law is to reflect the community's expectations and sentiments, which I'd submit as an uncontroversial proposition, then if we put aside what I would agree with Mr. Toomey to be the somewhat emotive expression of moral accounting, why shouldn't that person's good acts in other aspects of their life be considered? I would submit that would form a natural part of the community's expectations as to the approach to sentencing. So that's a justification
for moral accounting, if you want to call it that,
yes,
on the basis that the sentencing process should accord with community expectations, and in some cases the community would expect that it would be taken into account.
That's so, but also with this very significant caveat, which is also rooted in community expectations, and that is that where the objective seriousness of the offence or other countervailing measures dictate that good character should be put to one side, that it is indeed put to one side, and it would be.
Yeah.
It's the universality of the approach of this bill that we have a difficulty with.
Yeah.
Yeah.
Can I just ask, one of the, I think it was in your submission, was a suggestion that perhaps the exclusion which is contained in section 21A relating to the circumstances of the offence should be included for people who have a cognitive impairment, that good character evidence not be available in relation to offences against them, or alternatively persons under special care. Do you want to explain how you would see that as a possible extension of where good character evidence would be
excluded?
Yeah.
I think this is just, as well as the current exclusion which operates for child sex offences, I think we would be suggesting broadening that out to include sexual offences against other extremely vulnerable people, such as adults with intellectual disabilities, or the special care offences, which mean sexual intercourse with a child aged 16 or 17 under your special care, so if you're a teacher with a student. So I think the proposal was perhaps to be extended out to sex offences against other particularly vulnerable groups, not just children. So I think that was the only, if your position, which of course in one of those special care offences, inherently your position allows you to commit the offence, that they would probably also be appropriate offences where character, your good character allows you to perpetrate the offence and therefore should not be taken.
So a sexual offence potentially against, say, an elderly person.
Potentially an elderly person with dementia, perhaps who's cognitively impaired, yes. I think it would need to be given more thought, but I think children, of course, are the most vulnerable people in our community, but they are not the only vulnerable people when you look at the kind of vulnerabilities some adults have as well. Thank you.
Okay.
Just one more from me, if I could. Yeah. Just a general question. Seems to me that in the criminal justice system, social advantage operates to the benefit of offenders in lots of quite legitimate ways. So, for example, you're more likely to come before the court if you're socially disadvantaged. Lots of types of offending sort of correlate to varying levels of advantage or disadvantage in different ways. Those things are quite legitimate, I think, in the operation of the system. I mean, how often do you think people are coming before courts, and obviously those things are going to be considered if they're a person who has a low risk of reoffending, or high prospects of rehabilitation on account of their background circumstances, those things are going to be considered. But how often do you think that socially advantaged people are getting some mitigation of sentence on account of a sort of extraneous history of quite good acts, like they might have donated to charities a lot because they're advantaged, or they might have done all sorts of things that you're more likely to be able to do if you're advantaged, but which don't speak particularly to reoffending or rehabilitation? How often is that? Is it really working that way in the system?
I think it's probably very difficult to quantify in any concrete way. I would suggest probably nowhere near as often as perhaps what might be otherwise suggested. And that is because my experience has been that judges of the local court and the higher courts will always consider first and foremost the objective seriousness of the offence. And so once that occurs, this is just one of numerous factors which are taken into account, as Mr. Toomey described, in the instinctive synthesis of sentencing.
Yeah.
But equally, people of disadvantaged backgrounds are not inherently criminal. People of disadvantaged backgrounds often are able to call upon evidence of their good character. And as I say, the danger that we run in Ghent, it's made very, very clear that good character may only be an absence of prior convictions, but it sometimes refers to a more positive history in the community and a history of good works. So if we restrict good character to simply the letters that are written, that I would submit is not the correct way of approaching the issue of good character. Good character is a very broad umbrella of evidence, and that's I would submit a very important point for this committee to bear in mind in considering this bill.
So do you think courts have sort of let us down in a way when, and I'm thinking of George Pell, I don't remember exactly how many character references he had, but I remember there was a lot of high profile people. I mean, do you think courts have sort of let us down a bit by allowing the admission of really big quantities of statements from very high profile people, which at some kind of degree of volume maybe start to suggest that there's some relevance to the status of these people or some relevance to the volume of material? I mean, is this something that is a legitimate criticism of the existing system, do you think? Maybe Mr. Toomey?
I don't want to comment particularly on the Pell case, but it needs to be borne in mind that evidence of good character can be received as to criminal liability as well. I think every case has to be approached on its own facts, that there would come a point where a court would take the view that doesn't matter how many references you give me or how much evidence you call of good character, the objective seriousness of the offence is so overwhelming that this is an exercise in futility. But one can also conceive of a case where a person has been so community-minded and performed so many good acts for so many people that it would be desirable for the court to receive the evidence. I think it's very difficult to make any universal statement about that. And our position, which I think is plain, is that we have to place trust in the judicial arm of government in the sentencing process. Judges are experienced at it. Most of the people who are engaged in it have come from deep experience of criminal practice, and they are capable of distinguishing between evidence which has weight and evidence which should be given no weight. And that is really our position, that you do not want to be throwing out the baby with the bathwater.
There's an important distinction between admissibility and weight.
Yeah.
And classically, the sentencing exercise admits of a lot, but doesn't necessarily afford equal weight to everything.
Yeah, and that's why I was making that point about it not being an admissibility provision. It sort of concerns me that maybe the defence, those concerned with the interests of the accused and also the system more generally, in their criticism of this bill, and that's an understandable sort of attempt to put a position, might create an effect if it's passed, that it's interpreted as being a departure from existing practice that it's actually not. Because I think if courts, if this is passed, reject, even if something is headed good character reference, if a court rejects that, I think a court's probably going to be in error, because it might well be that the statement of good character is relevant to some other purpose or principle. But the sort of criticism and the very understandable putting of concerns might sort of feed this idea that gives it a bit of a rogue, a bit of an unintended operation. Because it's really something that's going to the end process of consideration, I think, rather than the evidentiary procedural stuff. Sorry, that's just a bit of a rant.
Thanks.
Take that as a comment.
Is that a submission? Government's position. Thanks very much for coming. No questions on notice. We'll now take a break and return at 11:10.
No, I don't think it's half an hour, it's only
10:45.
No, well, 10:45. what it was supposed to be returning at, unless you want 4 minutes for a cup of tea.
11 o'clock.
Sorry, so 10.
Come at 11 o'clock. Could each of you please give us your full name and title and swear either an oath or an affirmation, starting perhaps with you, Mr. Morrison.
My name's Isaac Morrison. I'm a solicitor advocate at Legal Aid New South Wales, and I'll be swearing an oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. And Ms. Fraser?
Good morning. I'm the convener of the Management Committee of the Feminist Legal Centre Clinic, and I'm offering you an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And Ms. Kerr?
I'm Anna Kerr, Principal Solicitor of Feminist Legal Clinic, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Would any or all of you like to give a short 2-minute opening address?
Yes. Janet and I both have short statements.
Yep.
So Feminist Legal Clinic supports a proposal to remove consideration of character references, but only in relation to child sex offences, sexual offences generally, and domestic violence offences generally, all of which are on the rise and are offences which are often committed by serial offenders who are often able to escape detection due to the private nature of their crimes, and which also have notoriously low rates of conviction and lenient sentencing. The focus of the victims groups campaigning for this change is on these kind of offences and not on property offences, public order offences or victimless crimes. The proposed bill is therefore way too broad in its ambit and should be replaced by a far simpler amendment. The current section 21A, subsection 5A, applies only to child sexual offences, but could easily be amended to apply to sexual offences generally and domestic violence offences. The current caveat is also too difficult to satisfy. The words, if the court is satisfied that the factor concerned was of assistance to the offender in the commission of the offence, should simply be removed. I began my career as a defence lawyer with the Aboriginal Legal Service. I've also worked for other places, including Shopfront Youth Legal Centre, so I have a lot of sympathy for the submissions made by the ALS and other groups, largely representing the interests of defence lawyers. However, they are somewhat overrepresented, I think, in the inquiry today. Since founding Feminist Legal Clinic, I have specialised in domestic violence advocacy on behalf of women, and I share the concerns about the widespread problem of female victims of domestic violence being misidentified as perpetrators. However, this is an issue that should be addressed itself separately as a matter of urgency, and I support DV New South Wales' call for a systemic review of the Crimes, Domestic and Personal Violence Act 2007 as a separate matter. Thank you.
Thank you. Any others?
Yes.
Ms. Fraser?
I'd just like to quote a couple of words from Veen and the Queen. Sentencing is not a purely logical exercise. Our submission is that we're deeply cognisant of balancing rights and interests with the community's need for justice to be done, and acknowledge there is no easy way to devise sentencing for diverse crimes and diverse offenders. Many submissions underscored the need for a level playing field in justice, yet we consider a level playing field does not include character references, where the rich may provide luminaries to attest to their character and the poor may not. We acknowledge the sentencing of sex offences against children comes with the proviso that character may not be included where it led to abuse of a position of trust. However, we think in general a serious crime threshold might be considered, past which character references will be forfeit. We acknowledge our colleagues' concerns about women being misidentified as perpetrators of violence as a serious systemic issue, but consider it better managed by police training and social change. Finally, as Section 3A sets out the 7 purposes of sentencing, I draw your attention to denunciation, particularly as articulated by His Honour Justice Kirby, who said in Ryan and the Queen, a fundamental purpose of the criminal law and of the sentencing of convicted offenders is to denounce publicly the unlawful conduct of an offender. This objective requires that a sentence should also communicate society's condemnation of the particular offender's conduct. We would suggest that the denunciation of serious offending is incompatible with the use of character references. Thanks.
Thank you. Mr. Morrison?
Legal Aid has provided a written submission and I'm content to rely on that.
Okay. All right. Crossbench.
Thank you.
I just would like to go to your submission, Mr. Morrison. Your view, or the view, of the Commission at this point is that you noted the persuasive and strong dissent views of the dissenting members of the Sentencing Council. And one of the things that you have put in your submission is that you acknowledge the need, the need to address the concerns raised by victims of child sexual abuse, and that you suggest that this inquiry should be exploring more and adopting more appropriate other mechanisms, including appropriate terminology to describe an offender's lack of prior offences or positive community contributions outside of their offending behaviour. Can you just extrapolate on that a little bit for us?
Yes, certainly. And I'd agree that compassion for victims should be a feature of the sentencing exercise. But Legal Aid's position is that that should be balanced with fairness to offenders. In terms of how the sentencing processes could be adapted to appropriately providing for that, there are two things that probably need to be considered. The first is the language that is sometimes adopted or used in sentencing remarks. Phrases like referring to someone, particularly who's being sentenced for example, a child sexual offence, as a pillar of the community or someone of otherwise good character is understandably something that can bring harm to victims. Having said that, judicial officers overall are very sensitive to these issues, and that's something that I have found in my practice as a solicitor and a solicitor advocate. Perhaps providing for further education, both for judicial officers and also solicitors, is something that could be used to combat these harms if and where they arise in the sentencing process. And that's something that Legal Aid does engage in terms of our provision of programs, both for solicitors in-house and more generally, opening up this conversation to speak about how we can address this in the way that we present cases. And in my experience, the most effective way to present and argue cases is one that acknowledges or is empathetic to the experiences of victims, both in the offence itself, but also in the sentencing process.
Thank you. And this is for all whoever wants to, Legal Aid and the Feminist Legal Centre, but Sentencing Council member Felicity Graham, a barrister who worked for the ALS for many years. Actually, and I just want to note, the ALS is not one of the only bodies that is not able to be here today, because of course they just don't have the capacity to be here. They've provided a really, really helpful submission that I think is very consistent with Legal Aid's submission. But Felicity Graham, a barrister who worked for the Aboriginal Legal Service, submitted that the most profound concern about use of character references arises from sexual offences and serious offending, rather than the 90% of summary offences and victimless crimes, such as drug offences and other forms of offences. So I think your evidence so far is consistent with you don't necessarily oppose the continuation of and consideration of character for crimes in those other categories. Is that confirmed, all of your advice, your evidence?
Yeah, that's right. We're not asking for a blanket removal of consideration of character in sentencing. In fact, we think the bill is far too far-reaching in that regard.
And in that sense, do you see that there are, and perhaps for you, Mr. Morrison, do you think that there, if the bill was to pass in its current form, can you already in your practice see that there will be consequences that would not assist in the administration of justice as we know it in the public interest in New South Wales?
Yes, certainly. And legal aid, along with the Aboriginal Legal Service, would represent a significant portion of those 90% of offenders that come before the court and are dealt with at the local court level. One of the major things perhaps that might be lost would be the sense of connection that the offender feels with the justice system and the process as a whole, which is also beneficial to the community. Anecdotally, one of the first things that a person who comes before the court will tell their lawyer is that it might be, I have a boss, or I have a friend, or I have someone that I've been doing community service work for or with. Perhaps even before they've even entered a plea, that's something that's relevant to them and that they want to be known for the court. And when the court who's sentencing the whole person rather than just a de-identified offence, that's something that's very important for the court to take into account, both in terms of its understanding and the information they have about that person, but also when exercising the prerogative of mercy. Because in my experience and the experience of many of my colleagues, people don't come to court with character references asking for their conduct to be excused when they're being sentenced, but they come asking for mercy. And when a person comes to the court in that respect, it's vital that the court has information not just about their prospects of rehabilitation, not just about whether they might be a risk to the community, but about who they are and what their circumstances are.
Thank you. Ms. Boyd, did you want to?
Thank you. If I could ask you, Mr. Morrison, just on that point of the original campaign and call for sentencing reform was in relation to child sexual offences. In your submission, you set out the sort of main reasons why you might want to keep good character. Do you see any of them as applying to child sexual assault, or do you view that as being in a different sort of category of offence?
Well, I think the important thing to recognise is that when, in terms of sentencing, a court will have to sentence a wide range and diversity of offences, as well as a wide range of offenders. And so it's not easy to categorise all people who are convicted of a particular offence in a certain way. So, for example, legal aid represents a lot of people who are convicted of serious offences, who might be young people, who are at varying stages in their development and their moral character, as well as other vulnerable people, for example, people who are suffering from a cognitive impairment, acquired brain injuries, or extreme levels of social disadvantage. And so, yes, legal aid's submission is that to remove good character from sentencing across the board could have very profound impacts for people who are at the extremes or the edges, who might even be convicted of those more serious offences.
But in relation specifically to child sexual assault, if we've still got the ability to put in evidence that goes to rehabilitation and evidence that goes to reoffending, what is it that could be relevant to still be captured in that general sort of good character section of the Act?
And I think it's a good point that those two categories are going to be particularly relevant in sentencing for those kinds of offences. But to ask the question, what is it else that could be significant for sentencing in those kinds of questions, really resolves at the individual level, and it would depend on a case-by-case basis. But the examples I've given of people that are in those categories who might not be considered as the target of this kind of legislation, there could be aspects of their background that are missed because good character is prevented from even being considered.
So on that, because again, so we've got the rehabilitation evidence, we've got the reoffending evidence, that's all still there. We're talking here purely about this kind of general nebulous concept of good character. If all of those objective factors are still taken into account, at what point does it become relevant that you have a subjective opinion from somebody that somebody is a good person, despite the fact they've gone and done what they've been found guilty of. They've been found guilty of a child sexual assault, and then you've got all of that other evidence still there. What is it that we're trying to protect, I guess, in that little slither of what's left that would justify keeping it for child sexual assault offences?
Well, first of all, I wouldn't necessarily agree that good character is a nebulous concept. It's something that it's a term that people would use and would understand quite well in the community. Secondly, when talking about the slither that's left, in fact, if the law prohibits any kind of evidence about a person's character being admitted other than for the purposes of rehabilitation and prospects of reoffending, then good character would encompass everything that is left in that respect. But it's legal aid and my experience that in representing people who come from disadvantaged, vulnerable backgrounds or who might suffer from cognitive or intellectual difficulties, aspects of their character that go to their resilience, through their ability to maintain conduct even through adversity, is something that could be relevantly considered by a court and may in fact impact on the sentencing exercise or not, because the court has the discretion. Sorry, in child sexual assault offences though. And again, that's a matter that I think would be resolved at the level of individual cases.
Yep. Thanks, Chair, and thanks to you all for coming along. Firstly, for Ms Fraser and Ms Kerr, if I could, I noticed in your submission, this is on the first page under the heading threshold, you say sentencing for sexual assault, child sexual assault, domestic violence and other violent offences should not be lightened by supporters attesting that the convicted person also performed previous good deeds. Is that statement accepting that there's an aspect of what's called good character in proceedings before courts that is not about good deeds but is about a person not engaging in like conduct in the past? And I'm curious just to tease out what you see as the difference between the two, because it seems to me that that evidence that goes to good character is generally either evidence of really good things that you've done that might be kind of extraneous to the offending, history of volunteering in the community, things like that, and then evidence that goes directly to the question of not engaging in that behaviour before. So you might lead evidence, for example, from someone's previous partners to say that person never abused me, I always found them to be calm and not angry, etc., etc. So that seems to me to be two different types of good character. And I'm interested in the type that relates to not acting in a like way before. Is that still a legitimate part of sentencing, do you think, even?
I think it might be legitimate in other areas, but for child sexual abuse, it's extremely problematic. And I'd suggest even domestic violence, it's extremely problematic. In the scenario that he can bring along a previous partner, for instance, you don't know what coercion she might be under to give that. So I think in those discrete areas of domestic violence and sexual violence, I think, the idea that you'd be able to bring along someone who said, well, he hasn't done it to me, I don't think that should be allowed in. Obviously, their previous criminal record will be considered in any case, and that's a separate matter. But they may well be they may have a very strong veneer of respectability, and that's the whole issue, and that is then reflected sometimes in lenient sentencing, and there's a lot of material to indicate that that's a problem. Do you have anything to add?
That's our position.
So the rationale in respect to domestic violence was something that I was particularly interested in asking that question. So is your view that the rationale for a special rule for domestic violence, so that character's not considered, is that sort of in principle, or is it because of the sort of realities of the world and sentencing that mean that it's unlikely to be accurate?
I think
do you think it's more of a conceptual
It's a
thing
bit
as well?
similar to the sexual things in that it's very private. The victims are often ashamed and don't want to speak out about it. So it's kind of different from a lot of other areas of offending.
Yeah.
Like drink driving or something. I mean, there's a question whether character should come up there, but I think it's got particular characteristics that we all should be concerned about. These are offences which are rising in frequency, and yet there is a pattern of low conviction, low charging, low conviction, and lenient sentencing. There's a concern, I know, within victims groups that members of the judiciary may have a particular personal bias against heavy sentencing for those particular offences. And we've talked about judicial training, but I don't know whether that's sufficient, because if the concerns of some victims groups are valid, it doesn't matter how much training you have. I know I don't want to scandalise any court here, but if you've got members of the judiciary, for instance, who are themselves perpetrators, which would not be known to the public, that may be reflected in lenient sentencing.
So do you think courts generally operate on a sometimes unspoken assumption that if a person has no prior convictions, that they have not offended before?
Yeah.
Yeah, is that your sort of...
I think that's an obvious concern. There's no evidence that they've offended before. So, and then if they have a good character witnesses, saying that they're good character, I think that's, in fact, you will hear statements of that type. When we know, of course, that there tends to be a pattern of offending that over many years before these individuals are identified as perpetrators and brought to justice.
Yeah.
So that's very hurtful for the victims who are sitting and listening to that.
So if you're talking about crimes that are unintentional, so for example, traffic offences that are strict liability, there's a whole range of different things. Why is there a greater rationale for considering character in respect of those as opposed to domestic violence, for example?
Because I think they can be considered, there can be situations where they constitute mistakes. People have made mistakes, maybe they're under some sort of pressure. Normally they act in a law-abiding fashion, but on this occasion they were suffering under various other factors, and so then you can bring character evidence to say this was out of character. They wouldn't normally do this. Now with child sexual abuse, how can you do that? Do you know what I mean? They're always going to say it was the only time. It was the only time I touched a child, but no one's going to be able to. I
it's
think
very rare in respect of all types of offending, though, for either a person on their own admission or a court in sentencing to sort of either admit that they've done it before or a court to accept they've done it before in the absence of prior convictions.
That's true, but I think there's something particularly traumatic for victims to have to sit there and listen, because often there is, from the victim's perspective, copious evidence of other offending. But that because of the peculiar difficulties of bringing, for instance, child sexual abuse to justice, that they will then have to sit through this talk of good character.
Yeah.
And I think that Section 21A5A tries to pick up that thing that the veneer of respectability actually allows the offender to keep offending.
Yeah.
So I think that's kind of unique as well, and that's true for both domestic violence and child sexual abuse, that they are able to continue because they are so respectable. No one's going to believe these allegations. So I think these crimes are a bit different from, like for instance, drug offences and things like that are very different, I think. Yeah. I think close family members are aware of it, and I guess there could be similarities, but I think we've got a particular problem with child abuse and domestic violence in terms of bringing those people to justice.
Yeah. So in terms of domestic violence matters, for example, are you saying that a court should be prohibited from making a finding that a person is in truth a first offender?
I think they're just making a finding about the offence before them.
I know, but let's say the lawyer says, look, we want you to go further in this matter, unusually perhaps. We want you to make a positive finding. It could be for seeking a particular outcome or just to prove it, but they say, look, we actually want you to make a finding that this person's never done it before.
Well, that would be inappropriate, I would have thought. How can a court can't make a finding on something that they have not got evidence before them about? And that would be an inappropriate exercise, I would have thought, by any court. I guess in the lower courts, in the local court or something, you could be asking for, Section 10A or something. It's pretty inappropriate in domestic violence and child abuse.
Except
I don't think they give those for...
you might, for example, have someone who was in a long relationship their whole adult life, then that marriage ended, they got into a new relationship, an incident of domestic violence occurred in particular circumstances, they seek to call their former partner and everyone else who lived with them and children and whatnot. There's a dramatic difference in the two relationships. I mean, why would it not be legitimate to seek a finding that this is a one-off?
I could see lots of red flags.
I mean, I can too.
Lots of previous partners are still under
I'm very aware
duress
from their former prosecutor of DB.
I won't pay the school fees if you don't come to court.
I know,
and give
but
evidence.
you can't apply those very important understandings as a categorical rule either, because you can then risk injustice. So, in theory, why shouldn't a court be able to make that finding?
Because that wasn't the offence before them and they won't have evidence to back it up. I mean, absence of evidence is not evidence.
I know, but the scenario that I just sort of raised is where it's a pretty complete evidentiary picture, if you choose to accept it, and you'd have a lot of caution. I suppose what I'm leading up to is courts are called upon to make findings as to risk of reoffending and prospects of rehabilitation. So how do you, in case of domestic violence, even through putting in a special rule, it's not going to operate to prevent a court from making findings about an absence of similar conduct, is it?
No, but at least we can stop this practice of putting, volumes of material of good character. And I mean, I think the George Pell example is a good one as to why the community has really had enough of this. But I mean, it happens to a lot of ordinary people, not just those very high profile, that they have to sit through good character evidence being led. When it's a charade.
Yeah. So just lastly, if I could, would you accept that a special rule for domestic violence would have as its objective not allowing consideration of evidence of extraneous good acts rather than preventing consideration of an absence of similar conduct?
I don't know how they could bring evidence of an absence of similar conduct. But, for instance, a couple of people have given examples of war heroes.
Yeah.
I think it'd be extremely inappropriate to bring evidence that this person is a war hero and therefore the court should be somehow lenient in their sentencing of them for domestic violence or child sexual abuse. That's the thing that I think. And I think that sort of thing does happen in the courts. And it's completely inappropriate. And very
sure, because that's extraneous, meritorious conduct.
That's
nothing
right.
Really
So
to
you're
do with
saying
defending. What I'm talking about more is an absence of similar conduct in the past. You're not seeking to say that that's not relevant, are you?
No, of course. If they have no criminal record, that's a factor that will be considered in sentencing. No previous record.
Yeah, that's a separate consideration, though, right? Because that's said to go to moral culpability because you've never stood before a court before and then gone on to reoffend after that.
Yeah.
I'm talking about something that goes squarely to that question of just not having done it before.
I think that's, I think that would be an inappropriate exercise. I mean,
except it's relevant to risk of reoffending, isn't it? Surely, which has to be a central consideration in domestic violence matters.
Psychologically. I mean, usually when you have domestic violence victims, they outline not just one incident. I mean, if it was just one incident, then that would be part of the facts, that he lost his temper and did something. Normally, it depends on the type of case, actually. So sometimes there are just one incident, in which case you can say there's one incident. Even the victim is saying there was one incident. Whereas, often with child sexual abuse as well as domestic violence, there's a long train of events over a number of years. So in that case, I think, yes, it would be inappropriate to say, oh, this is the first time, because, because obviously there's been So it depends on the individual case.
Yeah.
Look, I think often there's been a long history.
It's
sure, yes.
You've heard, perhaps I'll just continue with that. One of the things that you've heard, it does depend on each individual case. Mm-hmm. Why isn't that the appropriate potential amendment which we would seek is, rather than rule out good character evidence, adopt the position that we give it no weight as the proportionate response to ensuring that we are looking at each individual case on its own facts. There will be some cases where you would give the so-called good character evidence no weight.
Well, judges have that discretion already. They could already do that, give it no weight, but this would make them have to not give it weight, so that there's a difference. One is mandatory and one is discretionary.
But just to the questions which Mr. Lawrence was just putting to you, you would accept, would you not, that there are some cases where potentially it should be given some weight?
I think there's...
Based on the individual circumstances.
Are we talking about child sexual abuse and domestic violence, or are we talking about all offences? I'm perfectly happy for character references to continue for the run-of-the-mill summary offences. I've represented many people, and being able to bring the soccer coach says that most of the time he's well behaved and a polite young man, and he doesn't generally do this. I can see that there's situations where that's very helpful, and it isn't just for the wealthy. I agree with what has been said by other people today, that disadvantaged people can get some small help from character references, but not in these sort of offences, not in child sexual abuse. It's completely inappropriate to be bringing, the soccer coach says he's a good bloke, or he was a war hero. It's very inappropriate to even be going down that path,
And in those circumstances, you would expect it to be given no weight in those. But because there is a role, is there not, for judges to hear victim impact statements before they get to the point where they're assessing character evidence or other evidence relating to sentencing process. Yeah. So as part of sentencing, the judges are already taking into account, are they not, victims' impact statements?
One would hope so, but looking at some of the very lenient sentencing that we're seeing for child abuse, for instance...
Can you give me some examples?
No, but I could take that on notice and get some to you.
Okay, well...
Yeah, I'd be happy to do that.
In circumstances where potentially you say weight has been given to character for the purposes of sentencing where it was inappropriate.
All right, well, I'll take that on notice, and we'll do some research for you and send you something after today. I don't have those references off the top of me.
Yeah, that's okay.
But I would suggest that, a trial is about the state versus the accused, the offender, and the victim impact statement comes at the end of that very long process. And it was devised in order to allow victims to feel that they had some kind of voice in the proceedings, because they don't really, they're cut out, they just become a witness to what happens between the state and that accused person. So I think it's not on a par to have character references with the victim impact statement.
But it does go to the fact,
aren't similar.
It does go to the weight. The victim's impact statement would go to the weight which a judge would give to the character evidence, would it not?
It's definitely open to the court to find that, but there's no onus on the court to add that into the deliberation.
So if in fact the legislation required or included as part of what it required judges to do on sentencing was potentially to give no weight to character evidence as opposed to excluding character evidence, isn't that the balancing act which judges should be asked to do, and which they do?
Well, our position is that it really depends on the severity of the crime, so it depends on the offence. I think it becomes relevant to people who are engaged in lower level offending because, as my colleague says, and my other colleague, we want that for lower level offending in our case. It's a different ballgame.
So where does it click in that you take it out?
I think there is a difference. I've often thought as a society we do not distinguish between, for instance, crimes. One concern I have, crimes of violence, for instance, that are done for the gratification of the offender, as opposed to, for instance, someone losing their temper, or a spontaneous thing. So, I think child sexual abuse is particularly concerning because it's a crime that indicates a lack of conscience, and therefore it's very hard to detect, and it's very different from, for instance, a pub fight, assault that happening in that context.
Yep.
And so you've got a different type of offender that you're dealing with, and I think the impacts on the victims varies because you're dealing with someone. So it's not a situation where I made a mistake and I'm sorry. regardless of what they say, their real feelings are that they're hiding behind a veneer.
If I could just add to that, one of the concerns that we have about the bill is that it prevents any evidence of character being presented by an offender on sentence, which means, as you point out, that person is prevented from even raising or arguing that good character is relevant. And when we consider that one of the purposes of the court is to sentence the whole person, and particularly important is individualised justice in particular cases, preventing judges from exercising their discretion to, as you say, give some weight or no weight is something that represents a harm not just to the individual but also to the community.
Thanks, Mr. Morrison. There's one of the things that you do say in your submission is this: good character is not synonymous with social privilege and has not operated as something from which people of lower socioeconomic backgrounds are excluded. So it's your experience, this is what your submission says, good character can be demonstrated through lawful behaviour, community services, family responsibility, selflessness and honesty, qualities found across all socioeconomic areas. You recall saying that? The Attorney General argues for the total abolition of good character considerations, partly on the grounds that such considerations inherently favour the well-to-do at the expense of the underprivileged, including Aboriginal offenders. And that's not your experience, is it?
No, it's certainly not our experience.
And he expresses surprise that the Aboriginal Legal Service is opposed to the abolition of good service. How you no doubt have a crossover with the Aboriginal Legal Service in your experience.
Yes, I do.
How do you see the benefit of character evidence in relation to dealing with Indigenous offenders?
Well, two things. Firstly, character evidence is democratic in the sense that everybody has the opportunity to live a life that demonstrates that they've made a positive contribution to the community or their sphere of influence. And this applies to the wealthy middle class, white man, but it also applies to someone that's grown up in difficult circumstances in Indigenous community in regional Australia. For example, I have, and many of my colleagues would have had clients that have grown up with parents who have been incarcerated, who've suffered extreme kinds of disadvantage, been surrounded by drug use, but nonetheless demonstrated character in completing their education, in looking after younger siblings in that context, and in finding housing and the ability to even attain a level where they might be an elder in their community or a support to others who are going through difficult circumstances. It's something that a defence lawyer can present to a court to show that this person's not just someone who has committed this offence, but this person has a background, they have a character, and they've been able to make a contribution even despite the circumstances in which they found themselves.
So would you favour the idea of abolishing good character evidence for sexual offences and domestic violence offences?
That's not Legal Aid's position, and there's reasons for that. One thing that Legal Aid is concerned about, and has been addressed even here, is the misidentification of domestic violence offenders. For example, and this is a case that I've represented in the past, a woman may be charged with wounding her partner, and that might have happened in the context of many years of abuse at the hands of that partner. And that person may be able to say, I've got no previous offences, or they may not be able to say that. That person may be able to say, I'm at a low risk of reoffending, but that's not the point, because that person may have raised children, shielded them from harm in the context of a very difficult life circumstance. That speaks to her character, and that should be available for the court to consider, and maybe something that's prevented if there is a blanket ban on character being considered on sentence.
Do you want to question till another 4 minutes? Just to bring it to 1:45?
Yeah. Could I just ask one in relation to misidentification? And clearly that's a matter on the front of everybody's mind. And we've been pressuring the system in so many different places and regards to fix it, to stop it, to work it out, and to get better at dealing with this when police have those interactions. But the change is not coming, and it's not coming quick enough. You only have to speak with the ALS or legal aid to say, no, it's in the courts right now, it's happening all the time. What do you suggest in the circumstances? I know, so your position is quite clear in terms of the Commission, same as legal aid and a bunch of other submissions we've made. I'm interested in your perspective from the Feminist Legal Service, because you actually acknowledge this, you take this full throttle, yet you're suggesting that these there are, character references that go to character. I'm not going to recall them good character ever again, but references that go to character are just not, you're saying that they're no longer appropriate or they shouldn't be. Can you just extrapolate on that a bit more?
Well, I mean, although the number of women who are now being charged with domestic violence offences is becoming sizable and extremely significant, but I think that the issue is there's many more of those cases need to be defended, and they're not being defended. Women are often consenting to AVO orders because it's much easier and quicker to do so. There's a whole lot of systemic problems which I could address. It's another whole inquiry. But, so what we've got is a whole lot of people. I mean, it's like saying because there'll be some people who are falsely convicted, we shouldn't make this change. Because there'll be occasionally someone who's been convicted of a terrible offence, whether it's child sex abuse, and then, of course, they will suffer. But I think that the change, we should be designing the legislation for the scenario where the court has done its job appropriately and the person has been appropriately convicted, and this is a sentencing consideration. Because if we start thinking about what about the innocent person who's been convicted when they shouldn't have been, well, that's a whole different issue. We shouldn't have, like those women who shouldn't have been convicted as offenders because they're actually acting in self-defence or have been falsely accused. I mean, that's its own issue. Do you know what I mean?
Then how do you say, we don't have a post-conviction review system in New South Wales that's efficient or effective or works. So what do we say to these women? Oh, well, sorry, it didn't work for you. Sorry about that. You weren't able to bring
providing
any
legal representation to them would be, I mean, at the moment it's very, very difficult to get legal representation for some of these cases. For women who are defending these matters, there's quite a bit of pressure to just consent without admissions. Because that's just so much quicker and easier, and practitioners who take on these cases and have to take them to hearing, the amount that you are reimbursed by legal aid, for instance, for doing those cases is not very high, and so I think there's a lot of practitioners who would much rather get the client to consent, because the rate that you get paid for doing a quick mention where you consent to the orders is reasonable, but if you take a matter to hearing and you do it conscientiously, I can tell you, with multiple adjournments, I mean, it becomes the amount that you're being paid by legal aid to run those kind of cases can be completely inadequate. I don't know if I've answered your question.
Thank you. Our time for questioning has come to an end. I see, Ms Kerr, you've got a question on notice.
Yes.
You took on notice. The Secretary will be in contact with you. You'll only have 24 hours to respond, given the short time span, once you receive a copy of your evidence. There were no others, were there? Thanks very much for coming.
Thank you.
Thanks. Have the next witnesses, please. Taking letters from one group and allowing others to. Is that another one?
Is he not
Looks
here?
like not. Have we got a witness missing?
It's just one.
Oh, no, it's just Ms.
Oh, that one's with, oh, beg your pardon. Oh, I think I read it with that one. Okay, yeah. Okay, thank you. She's sitting off to one side, that's what put me off. Yeah, why not do that? She's not a
Might
left
just move
winger,
over
she
into
could
the
be a
middle.
right winger, who knows? She's in the middle, that's it.
Thanks.
No, that's it, that's good, thank you.
Thank you.
Okay, thanks very much for coming, Ms Cook. Could you please give us your full name, title and position, and swear either an oath or an affirmation?
Yep. My name is Rhiannon Cook. I'm currently Acting Deputy CEO with Domestic Violence New South Wales. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Would you like to make a short opening statement?
Yes, please. I'm here today representing Domestic Violence New South Wales, and I'd like to start by acknowledging that I'm on Gadigal land. This land was, is and always will be Aboriginal land, and I'd like to pay respects to Elders past, present and emerging. Our resident subject matter expert is on leave at the moment, so I'm here on behalf of DV New South Wales. I'll do my best to answer your questions, but also happy to get back to you if there are any questions I'm unable to answer. So DV New South Wales represents the specialist domestic and family violence sector, and we have approximately 200 members across New South Wales. I wanted to start my opening remarks with gratitude to survivor advocates Harrison James and Jared Grice, whose leadership of Your Reference Ain't Relevant campaign has brought about this proposed legislative change. I want to acknowledge the tremendous amount of strength that has taken to get to this point and the immense personal weight that comes with this work. Advocating in this space often means carrying not only your own experiences, but the stories, injustices and realities faced by so many others. And that kind of leadership isn't easy. It takes courage, resilience and an ongoing commitment to speaking truth even when the system is slow to respond. So DV New South Wales supports the campaign's recommendation that good character should not be a mitigating factor in sentencing for child sexual abuse cases, regardless of whether or not that good character played a role in enabling the perpetrator to commit the offence. And we also support broadening the range of offences for which good character references should be disallowed, including adult sexual violence offences. As we represent the specialist DVF sector, our focus today is on the experiences of victim survivors of domestic and family violence. And we recognise that sentencing processes can be an additional site of coercive control and re-traumatisation. And we agree that as a general principle, victim survivors should not be subject to hearing evidence of an offender's good character. We hold concerns, however, that the proposed changes could have an unintended impact on victim survivors who have been misidentified as the person using violence and charged with an offence. Misidentification of the person most in need of protection continues to occur across New South Wales, and there was discussion about that before, and it's been well documented by frontline specialist services. The consequences of misidentification can be profound. They can impact someone's ability to access safety, housing, parenting, employment, community connection and well-being. And we recognise that this is particularly common in coercive control relationships, and that Aboriginal women are more frequently misidentified as perpetrators of violence than other women. So we're concerned that without safeguards that go towards addressing this issue, these amendments risk reinforcing systemic inequities in the justice system. We acknowledge that the government is starting to engage on misidentification, and there's a lot of work to be done. We need to reduce the risk, the likelihood of misidentification, and ensure that where it does occur, it's identified and addressed early in criminal proceedings. So our feedback to this inquiry made 3 key recommendations to this end. They include a comprehensive review of the Crimes, Domestic and Personal Violence Act to align the law with contemporary evidence and lived experience, mandatory training for judicial officers and court staff so that there's a better understanding of misidentification, victim survivor resistance and coercive control patterns, and procedural safeguards to identify and address misidentification early in DVF-related proceedings. So we submit that legislative reform must proceed alongside a commitment to address the misidentification of those most in need of protection and ensure that victim survivors aren't inadvertently further criminalised or disadvantaged. Thank you for the opportunity to be here today, and thank you again to Harrison James and Jared Grice for their incredible advocacy.
Thank you. Questions?
Thank you very much, and hello, and thank you for coming and giving your evidence, and thank you for your acknowledgement of the amazing work that Harrison and Jared have done on the Your Reference Ain't Relevant campaign. So from your opening statement, I understand that you support, that DV New South Wales supports the reform in relation to child sexual assault and adult sexual assault.
Yeah.
I'm just want to focus then on the misidentification piece, which we can all agree is a major problem and is born out of, I think many of us would agree, out of systemic sexism, as well as racism when it comes to Aboriginal people, and particularly Aboriginal women. And I just wanted to look at Warringah Byers' submission to the Sentencing Council's process, where they do support good character reference being taken away as a mitigating factor for DV. And in relation to misidentification, they actually talk about, notwithstanding, yes, all of those issues that you've mentioned in your opening statement, that because a lot of what is judged as good character is itself subject often to sort of a racist lens, they say that they quote, "We consider the judgment of a person's character outside of an incident allows structures and systems to be reinforced of which Aboriginal women do not benefit." So in other words, they talk about how often Aboriginal women are more likely to be misidentified by police because of the assessment of good character being lacking in an Aboriginal woman is the basis of their submission. I guess, why does DV New South Wales take a different view to Warringah Byers on this one?
So I think it's important to acknowledge that there are different views amongst the in the domestic violence sector, but I think where we share a view is of the concern for those misidentified women, and so the difference is what is the outcome for those women as a result of being able to consider good sentencing at good character at sentencing. And other members have told us that it has been useful in making sure a conviction hasn't been recorded. So I think in our response, we would like to see a greater level of confidence in making sure those victims aren't reaching that point of the criminal justice system. But in the absence of being confident about that, we're worried about that unjust outcome for those women, and we think that more attention and research is needed there before a good decision can be made about whether or not this should be removed.
It's tricky, isn't it? Because we're dealing with a system that is inherently not working for many women who are being misidentified.
Yeah.
And then not because we love the idea of good character references, but because it might actually help some women in those circumstances. We're sort of not wanting to take that last salve away, I guess. Is that a fair...
Yeah. And I think, one of the factors that contributes to misidentification is an incident-based policing system where things are seen in isolation and taken out of context. So the broader context isn't visible. And this reform does that even more. It takes away some of the court's ability to look at the broader context.
The Warringah Byers submission makes reference to the UK position. Now, obviously, the UK is a very different place, and particularly when it comes to First Nations communities and the sort of overlaying aspects that we have here in our justice system. However, they have made reference to it in their submission. And in the UK,
the sentencing legislation effectively gives judicial recognition to the fact that an offender can maintain two separate personae. And so they can have a different persona to their colleagues and to their friends than they can within the home. And that reform really sort of has that sort of educational aspect as well as a sort of legal one. Do you see in the future, perhaps, if we can get to a position where we don't have the misidentification issues to such an extent, that we could consider this reform as a way to make it very clear that you can be a so-called good bloke and still be someone who abuses your partner?
Yes, definitely. I mean, our concern is very much about the high levels of misidentified women who are still part of this process. But if you could increase the confidence that that is not happening, or is happening to a much lesser degree, then removing good character, you could be more confident that the removal of that good character provision would achieve the outcome that it's meant to achieve.
Thank you. Just on this, thank you very much. This is incredibly helpful. But women who are victims who do offend and have offended and are objectively guilty, then they are the ones perhaps most in need of that reference as to character. Would you agree?
Yes.
Yeah, and this is the difficulty in terms of navigating that path. And we've heard evidence today that, and the stats bear out, you only have to look at Boxar, and that women are being charged in relation to domestic violence offences. And this is what our courts right now, I would be willing to say, are actually quite overwhelmed with compared to where things were some years ago. Without that interface of that capacity to obtain references, we are likely to see more women going through sentences that are more severe than what they otherwise would be able to be with the benefit of a reference as to their character.
Yeah, that's right. And then there are so many flow-on impacts from that, that it can make it harder for a woman to then find safety, be confident that she'll be able to find a job, be independent, leave a relationship.
And then, so the other thing in your submission, which I thought was a really important point, was that, we have heard a bit of evidence going to this, but you raised that many of your members your members report that many victim survivors will plead guilty to things such as common assault for really, really good reasons, i.e. it's too traumatising, it's too costly, it's too uncertain, and there are too many risks to children, housing, stability and so forth. And so I'm interested really in relation to that, again, how if this bill is left unamended, what we might see in those circumstances.
So if the bill isn't changed, I don't think I think we would still continue to see women who plead guilty for a wide range of barriers that you just mentioned. So I think it might have been Warringah Byers' submission that also spoke to some of the most effective solutions sit outside legislative change. And, for us, one of the big things would be about, a wider review of the Crimes, Domestic and Personal Violence Act, but also training for police and judicial officers. So we did some work on how our services interact with police a couple of years ago, and we did a survey, and almost half of the 93 services that responded couldn't agree with a statement that said that police are able to, accurately identify the perpetrator and the victim. So I think there's a lot of work to be done right at that end to make sure the policing response is more effective, and that stops things from, getting to this point.
And elsewhere, you have pointed out in a very effective means that the New South Wales government cannot commit even just 0.1% of the state budget toward frontline domestic violence support services, even during this crisis of violence against women. Would you say that fully funding the frontline would have a more significant benefit for victim survivors of domestic violence right now, rather than reform to character at sentencing?
Yes, absolutely.
Thank you.
Okay.
Well, I think the summary of where you've got to is that the best solution in relation to a lot of this is for less women to be before the courts.
Yep.
In relation to domestic, rather than remove the good character. Did you hear the evidence of Isaac Morrison before? Were you sitting here?
I heard part of it, yes.
And he made a reference to the fact that you can potentially have someone who is charged with a woman charged with a domestic violence offence who has been the carer of her grandchildren and circumstances where she has potentially prevented other domestic violence offences being perpetrated to others in that household. And I think the substance of it, why would you say that evidence shouldn't be before a judge who is dealing with an allegation or a plea by that woman?
So I think, when we know that there are women who've used violence in, retaliation or self-defence, who are coming before the courts, the ability to use that information so that there can be a better decision about whether or not the person who's being charged is the person most in need of protection or the main user of violence. Given we know that often it is the person in most need of protection who is being charged, that at the moment that information can be helpful.
Yeah. Well, but even on a plea, in relation to offending by that person, why wouldn't it also be important to know the actual life history of that person or the contributions that person has made to their own family?
Sorry, could you say that again?
Why wouldn't it also, if on a plea in relation to offending by that person, that we also know what the contribution of that person has been to the total circumstances of her family?
Yeah, so I think I'm agreeing with you that it is relevant at the moment, given the high number of misidentified women who are coming before the court.
Yeah. The Attorney General, when it was put before him, the evidence which you have put today, seemed to think it was an anomaly not to include domestic violence offences for the purposes of excluding good character, and yet to include sexual assault offences as part of a cohort of offences which would, in fact, attract no good character evidence. Do you agree with that as a sentiment, that you
I think
can distinguish between the two?
I think there's a difference between offences that can be done in retaliation or self-defence or under extreme duress, and that there are some offences that sit outside of that. So I think one of the people who presented evidence before talked about a line somewhere where it clicks in. And I think at the moment we don't know where that line is, but that more work needs to be done to better understand, do some quantitative research around the number of women who are being misidentified, what they've been charged with. But at the moment there's no sort of authoritative source of that evidence in New South Wales. So without that understanding, it's hard to know, where you can draw the line between the different types of offences.
You would have heard some of the evidence given previously, but by some of the lawyers who are involved in this process. they seem to fall on the side of the view that potentially more consideration needs to be given to an outcome where the education process understands that no weight would be given to good character evidence. Do you support that as a notion, that we actually educate that, sure, receive this material, but also for the purposes of sentencing the whole person, sometimes it will be given weight, but that on other occasions judges won't give it any weight whatsoever?
I think that that yes, education is important, but I think that the problem that the Your Relevance, the Your Reference Ain't Relevant campaign has identified is what that experience is like for victim survivors to sit there in the courtroom and hear that evidence. So I still think it shouldn't be allowed in certain circumstances, because even if you have an increased level of understanding and education around how much weight it can be given, the experience of having it presented is still traumatic.
Do you accept the notion, of course, that some witnesses have provided is that maybe what needs to occur is a change in the language rather than necessarily, as Ms Higginson refers to, as she no longer calls it good character, but just have it a notion of some sort of character evidence? So the re-traumatising of victims generally occurs against a background where evidence is being presented about, things that they've done in the community or whatever it is, and that re-traumatises on the basis that it's painted as they're a good person against their lived experience, that they're not a good person at all, and that's the re-traumatising event. And certainly the facts of the circumstances that they've been exposed to belies what they are now hearing about the person's contributions. So is language part of the problem?
I think that that would be an improvement, but it's, again, not the solution.
So is the solution to, in your view, to abolish good character evidence for a range of offences?
Yes.
And how do you decide which ones they are?
I think at the moment there are some where it's clearly inappropriate. There are some where there is no victim, so it's more likely to be appropriate, and there are some in the middle, which are the ones that we are talking about, where it's unclear at the moment, and more evidence and research is needed to work out where it is and isn't appropriate. Until that evidence is available, I think we've argued that there's a risk in removing it.
So is it premature to pass this legislation today?
In its current form, but we are supportive of removing the good character reference for, those child sexual abuse, adult sexual offences.
And the adult sexual offences, how do you categorise those? All adult sexual offences?
So we're coming at it from the perspective of victim survivors of DV who've been misidentified, and typically they are not charged with adult sexual offences.
But I just wonder when you're talking about adult sexual offences, how would you categorise those adult sexual offences? When there is violence attached to them?
I don't think I have the expertise to answer that question, sorry.
Yeah.
Thanks, Chair. Thanks so much for coming along, Ms Cook. Just a couple of questions from me. In your submission, you talk about misidentification. Are you talking there about people who are accused of committing criminal offences when in fact they're innocent and they've been the victim of criminal offences? Or are you also talking about people who may have committed criminal offences but in the context of an abusive relationship where they're primarily the victim, if I can put it that way?
Yeah, the latter.
Yeah, the latter, yeah. In respect of So in respect of that sort of person, so someone who may have committed a criminal offence in a domestic context, for example, a woman who commits an offence against her male partner, but she's normally the victim, if I can put it that way, and there might be a circumstance such as provocation, but not that sort of reduces liability or eliminates liability. Should that person have good character considered, do you think?
Yes.
Yeah. And is that, in your view, a thing that should be considered in terms of what prior good acts they've committed, so things that aren't relevant to the offence at all, or should it be consideration also of the fact that they haven't committed those sort of offences in the past, i.e. they haven't engaged in violent conduct before, or both?
I mean, our position and our research doesn't go to that level of detail, but it's around being able to consider the context in which that offence occurred.
Yeah.
So I think that's more than just, prior history. It's also goes to character.
Yeah. So would you say that the person who is the victim in that sort of situation, but is also a perpetrator themselves, and indeed in the context of that relationship, the primary perpetrator, should they have good character considered as well?
In a situation where they've been charged, or where they are the victim?
Where they've been charged out of that relationship and they're the primary aggressor in that relationship?
No.
No. So the basis for distinguishing who should get it and who shouldn't get it is who's the primary sort of aggressor, if I can put it that way.
Yep.
Yeah. And is there any other basis for distinguishing between those two situations, do you think?
No, I don't think so. I mean, I think that if the principle is an improvement to make the sentencing process less traumatic for people who really are the victims, then removing it makes sense. But you have a court system where the victim is also sometimes or often the person being charged.
Yeah. In terms of trauma for victims, could you just explain to us what you think in the current system is the cause of that trauma? I'm talking about trauma arising from the use of character evidence.
I think trauma is really complicated and it can be caused by all manner of things. But I think one of the characteristics of both sexual victim survivors of sexual assault and domestic violence is often a feeling that it's all in their head, that they're imagining it, that this isn't really a problem. And that reinforces that perception and that belief. Also just hearing people say good things about the person that has done bad things to you is traumatic.
Yeah. So how much of that do you think is, and this is obviously impossible to quantify, but do you think that part of that trauma is arising because if you've been victimised by someone, you will very often have the view that they're not a first offender in fact, that they've actually done it to other people as well? And yeah, I mean, that obviously depends on the context, but from my experience working in the criminal law, that's very often the case. People have that view, I'm definitely not the first or definitely not the only one who's been victimised by this person. And is part of that trauma the person hearing these assertions of good character that sort of jar against their own view about this person's real history?
I'm sure that would be the case in some situations, yes.
Yeah. So for the purpose of the way that a court considers character, do you see a distinction between a person leading evidence of prior good acts that have nothing to do with the offending and a person leading evidence of not having engaged in the conduct before?
As different, or...
Yeah.
I'm trying to think how that would apply to, the people that we're here speaking on behalf of. And I think the person who spoke before me spoke about evidence of, you know, a woman who has cared for her children, protected her children, as being relevant. And I'd agree with that. So I think that goes to evidence of good character as opposed to lack of evidence of prior offending.
Yeah. Because if something's a one-off, then if someone's able to prove that something's a one-off, would you agree that that's very likely to be relevant to the risk of the person doing it again?
Not in every circumstance.
No, it's going to depend. I accept that.
Yeah.
Yeah, but very often the best predictor of, as they say, the best predictor of future behaviour is past behaviour.
Yeah, I mean, I think when you think about the dynamics of domestic and family violence, and an actual physical act of violence might be only occur when things have really, the risk has really escalated, but there would be a whole lot of patterns of coercive behaviour that would lead up to that. So in that circumstance, I don't think that isolated violent incident would necessarily tell you very much information about the likelihood of future offending at all.
Whereas evidence of like particular good acts in the past, even if they've been quite sustained, it seems to me that they would very often really have nothing to do with the question of what the person's likely to do in the future. It just seems to me to be totally extraneous. Would you agree with that?
Good acts in the past. I think the answer is it depends.
Yeah.
And again, if you're talking about the good acts being, you know, a mum who's protected her children in a violent relationship and stayed in the relationship because she feels like that's the best way to continue to protect her children, then would you define that as a good act? In which case, yes, I do think that, you know, that kind of information is relevant to making a decision about the consequences for that person.
Thanks, Chair. That's my questions.
Where are we going? Finished? No more questions?
Did you ask? Could I ask, in a world where misidentification doesn't exist, just imagine, would you still be opposing this reform for DV offences?
No, and we're not opposing it. Rather, we're saying that it shouldn't be removed for all offences. That more work needs to be done to work out which ones it is removed for and which ones it isn't.
And just on that line of questioning, my colleague was asking. The idea that imagine we have the kind of stereotypical DV kind of offence, and you've kind of the victim, you've made out, you've gone to all this trouble to go and actually finally get safety. The perpetrator has been brought to account. They've been found guilty. What do you think the impact would be at that moment if there was some evidence adduced of their good behaviour in previous relationships? Do you think that could be ever relevant and, I guess, worth the trauma that would cause to the victim?
I think that there are enough other ways. I think we would be comfortable in those circumstances that that's not available information that's considered at sentencing.
Can you maybe explain, I guess, why based on this kind of the broader, we haven't really talked about the psychology of a lot of these offenders in relation to child sexual assault or in relation to DV, but do you think that even if you could adduce evidence that a person had never done this before in a previous relationship, that would be good evidence of whether or not they would even reoffend, like if it was sort of, evidence for that sort of purpose? Do you think it could ever be relevant to
rehabilitation or reoffending even?
I don't know that I am able to comment on that, but I think, I mean, coming at it from the principle about the impact that has on the victim in those cases, then I don't think that should be evidence that's presented when making a decision.
Yep. Thank you.
Okay, I think we're done with questions, are we? Yeah. Okay.
Thank you.
Thanks very much for coming today.
Thank you. think should we just start, Cameron? Let's do it. Great.
You want to kick off?
Yeah.
Okay. We'll kick off early. Mr. Tudor's got a lot of questions for you.
No.
All right. Thanks very much for coming. Could each of you please give us your full name, title and job description, and swear either an oath or an affirmation, starting with you perhaps, Ms Gregory.
Thank you. Prue Gregory. I'm the Policy Advocacy and Stakeholder Relations Manager at Samson, Survivors and Mate Support Network based in Parramatta.
Thank you.
And I'll give the oath.
Yep.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. And Mr Hughes Cashmore.
Hi, thank you. My name is Craig Jeffrey Hughes Cashmore. I am the CEO and co-founder of Survivors and Mate Support Network. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. And Mr James.
Thank you, Chair. My name is Harrison James. I am the co-founder of the Your Reference Ain't Relevant campaign, and I appear today as a victim survivor of childhood sexual abuse. I welcome the opportunity to give evidence to the committee in support of this important reform and to speak on behalf of survivors who have been directly harmed by this practice. And I'll go for an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Would any or all of you like to make an opening statement, perhaps starting with you, Ms Gregory?
Thank you. Yes, we will be making an opening statement. I would like to begin by saying that our expertise in this amending legislation is restricted to victim survivors of child sexual abuse, so that's going to be section 21A3F, the amendment to 21A, 5A and the additional clauses. We're particularly concerned by the law as it currently stands, in that section 21A, 5A, currently provides two classes of victims and offenders, those that have been abused within an institutional context and those who haven't. The current law benefits offenders who have been in middle class offenders with strong community ties, but really importantly, fails to take into account the impact of hearing the statements being read out at sentencing proceedings, especially on the victim survivors of non-institutional offending. By preventing the use of good character references in mitigation of sentencing, the amending legislation will overcome a lot of the objections that Samson has to the current law.
Thank you.
I'll continue.
Mr Hughes Cashmore.
Not really, but I'll just say that I'm also a survivor of child sexual abuse. And about 20 years ago, I went to the police and reported my 3 offenders, and that resulted in 2 criminal trials.
Thank you. Mr James.
Thank you, Chair. For me, this issue is not about hypotheticals or whataboutery. I know what it is to live with the aftermath of childhood sexual abuse, and I know how easily legal processes can deepen harm for survivors rather than relieve it. I'm here today in strong support of this reform and in complete support of the recommendations made by the New South Wales Sentencing Council, including the abolition of good character references at sentencing. The Your Reference Ain't Relevant campaign has spent years advocating for this change because victim survivors should not have to sit in courtrooms and listen to the person who harmed them be described as a good person, a pillar of the community, or someone whose offending was supposedly out of character. We now know from the evidence base that underpins this reform that a perpetrator's perceived good character is in fact central to how they facilitate and conceal abuse. Good character references are not a minor feature of sentencing. They are deeply harmful, they re-traumatise survivors, and they shift the focus away from the harm inflicted and back onto the reputation, status and social standing of the convicted offender. The New South Wales Sentencing Council undertook an independent, expert-led review in a 126-page report, informed by public consultation, stakeholder engagement and significant legal and community input over a period of years. Despite all of that scrutiny, its recommendations still stood: abolish good character as a mitigating factor at sentencing. And as a campaign, we stand firmly by that review, by its thoroughness and by its findings. The question before this committee should not be what's easiest for the system to absorb, but what is just, evidence-based and fair. Victim survivors have already waited long enough, and every delay has very real-world consequences. Every extra day that this reform is stalled is another day that offenders convicted of child sexual abuse, rape, domestic violence and other serious crimes are being praised as good people in court. It is also important to be clear about what this reform does and does not do. It does not prevent judges from considering the whole person in front of them. Courts will still be able to have references submitted that consider prior history, remorse, rehabilitation prospects, youth, background, psychological evaluations and all other relevant sentencing factors. What it does remove is the purely subjective weight given to so-called good character references, which too often reflects privilege, influence and social standing rather than accountability. This reform does not remove fairness from sentencing, it removes one of the clearest ways that privilege enters it. Thousands of survivors across New South Wales and beyond are looking to this reform as a sign that the legal system may finally be prepared to centre their harm rather than the character of the perpetrator. I strongly urge this committee to support the New South Wales Sentencing Council's recommendation in full, and I look forward to answering your questions. Thank you very much.
Okay, thank you. Questions? Start with Mr. Shuto.
Thank you. I'll just start in relation to the Sampson position. Is your focus primarily has been on survivors of sexual abuse, has it not?
That's correct.
And I take it that the submission that you would make is for the removal of good character references in relation to child sex offences.
That's where our expertise lies, yes. But having also looked at the Sentencing Council report, we can see the benefit of removing good character references per se.
Did you read the dissenting submissions in relation to that report?
No, I didn't.
The dissenting submissions, by and large, dispel the idea that good character evidence is the main province of the privileged and upper middle class people. If I put that to you, would you agree with that?
No, I would disagree with that. Having worked in community legal centres for many, many years in disadvantaged areas of Sydney, I would have been struggling for any of my clients to be able to get a good character reference.
Well, Legal Aid and Aboriginal Legal Service all oppose removing, or both oppose removing good character as something which they would say is important for the people which they represent.
Yeah.
Do you disagree with the submissions that they make?
I wouldn't disagree with that. I'm talking about my personal experience as a principal lawyer in community legal centres, where it was often very difficult to find someone who would give good character reference for the offenders that I was seeing.
But for certainly people, in the evidence we've heard this morning has been that a cohort of very seriously underprivileged people benefit significantly by some form of character evidence on sentencing.
I would accept that, but I also think that this legislation doesn't prevent that evidence coming before the magistrate or the judge in sentencing.
Would you agree with the position that if the bill was confined to removing good character evidence in relation to sexual offences, that would be something you would support?
It would be, given the cohort of clients that we see.
So Domestic Violence New South Wales is also opposed to the removal of good character considerations for domestic violence offences due to what they say is a significant issue with women, especially Aboriginal women, being misidentified as the predominant perpetrator.
That is something that's not our expertise to comment on.
So to the extent that they have that concern, would you...
I would accept what they're saying.
What they're saying. The Advocate for Children and Young People and other stakeholders have also opposed removing good character considerations for all child offenders. For example, do you have a position on children who commit child sex offences? and secondly, on children who commit other offences?
I come back to the point that I made earlier, which was there are other ways of bringing that evidence in to the sentencing without relying on good character being the sole mitigation factor in sentencing.
So one of the things that has been put by the Bar Association is in relation to this offending, that is that no weight be given and that the Act be amended so that it is clear that in relation to a proposal of good character evidence that judges have the ability to give no weight to the good character evidence. Would you support that as an amendment?
I don't. No, I wouldn't, because I think it's making it overly complex. In that, what is the point of introducing good character evidence if there's no weight being given to it?
Well, because the High Court said in Ryan that it should be taken into account. So if you made it clear that in relation to dealing with the Ryan decision, that no weight would be given to that evidence, would you agree with that as a proposition?
Given what you've just told me, yes.
Mr. James, I accept the passion with which you've advocated for this reform, and I must say that I think that your contribution has probably been at the forefront of where we are today. You would have read the submissions of the Bar Association, the Law Society, Legal Aid, the Aboriginal Legal Service, Domestic Violence, and none of them are at a point that you're at, are they?
Well, I think it's entirely predictable that defence-facing organisations would oppose the removal of a recognised mitigating factor. Their role is to protect every argument that may reduce sentence severity for their clients.
Yeah, but they also reject a number of the notions put by you that good character evidence is the province of the privileged.
Well,
don't they?
Well, I reject that claim flatly. Look, for example, with Aboriginal legal services, I take concerns about disproportionate incarceration extremely seriously, but I do not accept that preserving good character is the answer. The Sentencing Council found that good character is unequally available and can privilege those with status, networks and respectability. If we want a less biased system, removing the subjective and status-based mechanisms is one step towards that.
Well, when you say that there is a status-based mechanism for the purposes of using character, on what basis do you say that's the case? Is there a body of evidence that you can point to? Because the evidence we heard from them is quite the contrary.
The New South Wales Sentencing Council report.
Yeah, well, is that contrary to what Legal Aid are telling us, contrary to what the Public Defender's Office is telling us, contrary to what the Bar Association is telling us, they say that doesn't exist.
Well, I don't agree with that wholeheartedly.
Well,
as a victim survivor of child sexual abuse, I understand the dynamics and how abuse is carried out.
I don't downplay that at all.
I'm not suggesting you are, sir, but I think the defence-facing organisations, as I said, it's entirely predictable that they would oppose this because their role is to protect every argument that may reduce sentence severity for their clients. That is a legitimate professional role, but it's not a neutral one. And if it is a position shaped by the interests of the defence system, and it should not be treated as though it were the same as an objective public interest view on what sentencing requires.
Well, you'd have to say, though, that would you not, that probably the Legal Aid represents the most underprivileged people who are potentially facing a court process?
Well, I'm increasingly concerned that much of the resistance to this reform is not actually about whether good character remains justified in principle, but rather about what its removal means for the convenience of existing actors within the system. So defence-focused stakeholders lose a recognised mitigating tool, corrections-facing stakeholders worry about pressure on remand and custody, system managers worry about flow-on strain, Those may be genuine concerns from their institutional standpoint, but they are not sufficient reasons to preserve a practice that New South Wales Sentencing Council found has no sufficient justification, is vague and uncertain, and risks re-traumatising victim survivors. And that is the core of why we're here today, sir.
Well, I accept that is the analysis which you bring to that. Would you agree with a process which sought to limit the offences for which good character evidence would be available?
No, I stand by the New South Wales Sentencing Council's findings.
Well, but even in relation to a circumstance where you have someone charged with an offence in circumstances where they have led potentially a driving offence, where there is an impact on certainly a victim in relation to a driving offence, but the person has otherwise led a life which is exemplary, and where the court is charged with the process of judging the whole person or sentencing the whole person in relation to that offending.
Sentencing should respond to the offence and the harm caused. It should not operate as a reward system for social standing, and that's currently what it's doing. Sentencing Council found that good character takes a very simplistic view of an offender, rewards irrelevant good deeds and reputation, and adds nothing of value that cannot be addressed by other mitigating factors. So to put it bluntly, people should not be sentenced more favourably because they are respectable, well-liked, powerful or well-connected. Equality before the law demands more than that.
Yeah, but we heard from the legal aid representative who told us potentially that we had a grandmother who was charged with a domestic violence offence, where she has been the carer for her family and potentially the protector of her family, who potentially themselves have been the subjects of abuse over a period of time. Why wouldn't that be relevant in relation to the sentencing of the whole person?
Because, as the Sentencing Council established, we can look at prospects of rehabilitation, remorse. There's a myriad of factors that can be taken into account. Good character is entirely subjective. The role of sentencing is to look at the objective factors as to how this offender should be sentenced. This is only happening in sentencing, at the back end of the post-conviction.
Thank you. Crossbend?
Yeah, sure.
Yeah, sure. Did you want to go first? Yeah.
Thank you. Thank you so much for all of you for coming and for your advocacy. Mr. James, if I could start with you. There's been a lot made of the people who have attended today, predominantly having sort of one view, I guess, but particularly in relation to child sexual abuse. I note that your position also has the support of Warringah Baya, Aboriginal Women's Legal Service, Samson, obviously, the Survivor Hub, the Grace Tame Foundation, Blue Knot, Bravehearts, the Fighters Against Child Abuse Australia, Life Without Barriers, NAPCAN, Domestic Violence Crisis Service, National Women's Safety Alliance. It goes on. So you're certainly not alone. The Rape Crisis Centre, Victims of Crime Commissioner. There's a lot here, and as you say, the vast majority of the Sentencing Council. So I'd say you're on pretty sort of strong ground. Can you explain perhaps one of the issues that keeps coming up is this focus on, we can't, and I think some of the comments that I read, if you are a victim of child sexual abuse, reading it is and thinking about it in that context is a little bit offensive. But the idea that we are, just looking at re-traumatisation of the victims. Can you explain why the so-called good character of a perpetrator of child sexual abuse is just not relevant? So as a, and perhaps that how it re-traumatises because it's not relevant to hear that information.
Yeah, of course. I think it's the thing with good character in the specific context of child sexual abuse is that it is not a mitigating. If anything, it should be an aggravating factor because it provides more evidence as to how they were able to facilitate and carry out the abuse concealed for so many years. Same thing with domestic violence, same thing with adult cases of rape as well. I think there's a broad, consistent theme of how these crimes actually operate, and to allow that in sentencing is essentially giving these convicted offenders a discount for the very thing that allowed them to facilitate the abuse in the first place.
And given the sort of, I guess, looking at this from the perspective of child sexual assault survivors and advocates for reform, one of the major hurdles has been getting society to understand that it doesn't matter what a person looks like on the outside. They may well be abusing your child. We saw that definitely in the child education, the early childhood space, where these perpetrators are seen as being really decent people, but that doesn't mean that your child is less, is any sort of less risk with those people. So from that educational perspective, can you explain what this reform would achieve?
Well, this reform would achieve, it would establish within the courts the understanding that this is how child sexual abuse operates, in that specific context. But also more broadly, it would it's not only a practical piece of legislation that's trying to be altered here, it's also a symbolic reform in terms of what this Parliament does by establishing this and passing it through the Parliament, is sending a message to the wider community that if we're confronted with the harm of child sexual abuse or any other violent crime, that we should not reach for that very loaded language of good character, pillar of the community, or he was a good bloke, I never saw anything like that, because it diminishes the severity of the harm that's been caused to victims, and it's essentially a gaslight of what they've experienced.
We've talked a lot about the need for our justice system to be more trauma-informed, both for DV victims and for particularly for sexual assault victims. If we have a situation where, after you've gone through all of the hurdle of actually making the complaint to police, having it believed, going through all of that, going through court, getting the person's found guilty, what message does it send to other people thinking about going through that process to get justice?
It tells them not to bother.
Right.
It tells them not to even try, because the thing with the system and why survivors are so apprehensive to report in the first place is because there are all those hurdles that you mentioned. And to think that you would go through the motions of reporting the crime, going through a tumultuous court case or a trial, where you are hearing all these factors and you are being told that you are being questioned over whether your abuse occurred or not, which is incredibly devastating in and of itself. To then secure that conviction, it's unequivocally, this person has been unequivocally found of child sexual abuse or whatever crime, and then to come back at sentencing and you think you have this feeling of as if you've completed it, you've been vindicated, and then to have these good character references read aloud is deeply traumatising and harmful, as the Sentencing Council established. Mind you, it is based in evidence that this is what occurs. And good character, it's a vague and uncertain concept. It rewards irrelevant good deeds and reputation, and it's not a reliable predicator of future behaviour. And courts have themselves acknowledged its poor predicative value. That's what the New South Wales Sentencing Council concluded.
Thank you. Thank you very much for being here. Mr. James, I just wanted to ask you about the fact that, one of the findings of the Royal Commission into Institutional Responses to Child Sexual Assault is that victim survivors of child sex abuse are 5 times more likely to face criminal charges than those who have not been victims of child sexual abuse. Is this something that you have seen in terms of the people that you support?
That's outside my... Yeah, I'm not familiar with that particular
Thank you.
issue. Yeah.
So would you necessarily then support or oppose, would you necessarily oppose a circumstance in which a victim of child sexual abuse who later commits an offence, whether it be traffic offence or a drug offence is prevented from providing evidence to court about their character. And I acknowledge the fact that you are of the view that you would still be able to present certain material, but in relation to character, and if we can take away the term good character, but character.
Yeah. With respect, I don't think we can take away the term good character because that's how the courts are currently operating.
But assuming if we were to reform that.
I think that there is a myriad of different options for the courts to consider that specific case. So I'm still in support of the reform as it stands.
Thank you. Justice Health data suggests 60% of women and 37% of men in prison reported that they had experienced childhood sexual abuse. So again, would you have concerns that victims of child sexual abuse are ending up in prison because of punitive laws as it stands, and that if we were to remove completely this ability for them to provide material that would try to show their character based on their history, their experience, the sexual offences that they have experienced and the abuse, does that provide any concern to you?
The courts will still... I don't know how, with great respect, I don't know how this is relevant to the actual call to action here with the reform, but courts aren't dismissed from prospects of rehabilitation. All those things still are retained.
No, I'm talking about character.
Yeah.
Somebody's character.
If I can
please.
answer that. Certainly, in a prior life, I was the principal lawyer of No More Legal Service, which was attached to the Royal Commission into Institutional Responses. We visited every prison in Australia and took statements of people who'd been in prison for various offences. Mainly they were property offences to feed a drug habit, and that's why they ended up in prison. If they were coming to me in my other life as a community legal solicitor and they'd been charged with those offences, what I would be wanting to do would be to talk about the impact of the trauma. The good character is not something that I would actually be referring to. I want to go back to look at how has the trauma of being sexually abused as a child, how has that played out in your life? And interestingly, when I visited someone in Long Bay prison, a young Aboriginal person who was telling me his life, which was pretty awful in terms of what he'd done. But he then talked to me about what he'd experienced as a child. I drew the attention of him of that abuse and his subsequent behaviours. He hadn't drawn that connection. And I think as a defence lawyer representing him, I would definitely want to be able to draw that attention to the impact of the trauma, not the good character.
Thank you. And I've just got one last one, if that's okay. Just in relation to your premise, Mr. James, and I'm not sure if the other witnesses hold this same premise, but that the idea that everyone from a defence-facing organisation, such as the Public Defender's Office, such as the Aboriginal Legal Service, such as Legal Aid, would somehow be looking as I think your evidence was the main objective is to lessen sentence. Do you at all entertain the view that as officers of the court, that their primary and principal role is to ensure that the sentence they receive is the one that is most fit for purpose in the administration of justice, or is that something that you don't hold or acknowledge? And I'm happy, Ms. Gregory, if you wanted to.
Obviously, you would want that to be the case, and I would agree, but there are other ways of reaching that, and probably more successful ways of looking at what rehabilitation that person has gone through, what their community connections are, what support they've got beyond just being of good character. And I would think that good character of itself is such an ephemeral notion that to be able to get the evidence of a social worker or a probation and parole officer as to what they've undertaken either in prison or in the community, whether they volunteer or that could be brought in.
And what about unrepresented people, which is a massive cohort
Yes.
in the local courts?
Yeah.
What happens there?
In my experience, most of the defendants at Darling Centre, there are duty lawyers present, and so someone would be presenting their case.
I'm sort of from the regions, which was where.
Okay.
So yeah, I'm just kind of thinking about the rest of New South Wales, which is quite large.
Yeah. I'm at a loss as to see how they would be able to introduce good character references by themselves in a proceeding.
The evidence before this committee is that good character is vague, arbitrary, unequally available and re-traumatising to victims, and courts will still be able to consider the offender's full circumstances. So I don't accept that preserving this particular mitigating factor of good character is necessary to achieving genuine justice for victim survivors.
Thank you.
Thanks, Chair. Thanks to all for coming along. Much appreciated. Just a question for you first, Mr. James. In criminal proceedings, character sort of arises commonly in two circumstances, as I'm sure you're aware. The first is in the trial on the question of guilt or not guilt. Normally, when it's led in that context, it's in the trial. There's normally cross-examination of the person who's asserting the accused good character. And I've seen it myself that a person who gets in the witness box in the trial and says this person's always been a great person is often subjected to cross-examination along the lines of, well, have you seen them in this particular context? Have you seen them in this particular context? Then the second circumstance is in the sentence phase. And I've noticed in the sentence phase that cross-examination on references is extremely rare. They're normally just handed up, and all sorts of things can be said in references and generally goes through to the keeper. And I'm just wondering if you think that the courts and practitioners in the courts, in a sense, have kind of created the situation by not testing assertions in the sentence phase and letting all sorts of material go before the judge under the rubric of good character, that in a real sense is untested opinions, it's evidence of general reputation, things that just are not that probative on any real question.
I can't speak to that directly, but to answer to comment on the sort of scenario that you've approached there. No one on this table or the New South Wales Sentencing Council is suggesting that we remove good character evidence from a trial, because that's an important factor to remain to establish the evidence before a conviction is resulted. We're only advocating to remove the arbitrary and irrelevant notion of good character in sentencing post-conviction, and it's also important to note that written references can still be given to the court in that sense. They just can't attest to their good character.
Yeah. So sometimes in the sentence phase, evidence is led as to whether a person has engaged in like conduct before. So similar to what is led at trial in terms of the type of character. That can sometimes be in a psychological report, so you might get a psychologist who sat down with the person and they'll give an expert opinion on how likely this conduct is to have occurred before, prior, why it occurred in the circumstances of the case. That psychologist or psychiatrist can then be cross-examined in the sentence phase. Are you concerned about evidence like that, or is your concern more about untested assertions as to reputation, prior good acts that are totally irrelevant?
As a victim survivor of child sexual abuse and someone who has attended courts and sentencing hearings alongside victim survivors because of my advocacy, my concern remains purely on the subjective. Like, imagine being a victim survivor who's experienced sexual abuse, gone through a tumultuous trial, and then you have to hear the person that raped you is a good fella.
Yeah.
It's absolutely devastating to sit there in that courtroom and hear that.
Yeah.
That is all I'm concerned about getting rid of, that victim survivors don't feel gaslit in the sentencing process.
Just a question lastly for you, Ms. Gregory, following on from Ms. Higginson's questions about victim survivors who become perpetrators. One And that's something that, as I'm sure you're aware, there's a line of case law that the courts have developed about how that matter is considered in sentencing. It's used as a mitigating factor in sentencing because there's an acceptance that in some cases, obviously a minority of cases, there can be a relationship in terms of the role that trauma plays in someone becoming or being a victim and then becoming a perpetrator. That's something that the courts understand as relevant. I'm just wondering about how you would see this new rule operating in terms of a person who has been subjected to that trauma, has otherwise had a blameless life, might have engaged in lots of good deeds. Their lawyer might want to argue that their prior history of good deeds and good character illuminates the role that the trauma's obviously played in producing the offending. How would you see this sort of rule applying in that sort of case?
I think I understand where you're going with the
Sorry,
question.
it's very
I just
long-winded,
wanted to clarify, when you're talking about a perpetrator, you mean an offender, not a perpetrator of sexual violence?
So I'm talking about, for example, a person who's been a victim of childhood sexual assault,
Yes.
who then might have gone on, whether as a young adult or an older adult, to offend themselves, offend in a like way, and is then seeking on sentence to explain the causative role of the trauma through illuminating other aspects of their life to then tie it to the trauma. That's something that I've seen in criminal proceedings. And I'm just wondering how this sort of rule, how you would see it operating in that situation.
And again, I'm assuming what you're talking about is the first proposed amendment, which is to get rid of the 3F, which is the reliance using that good character. I would be still very happy with the fact that subsection 3 gives a raft of other alternatives that you could talk to apart from good character.
Yeah, okay. I'll just go back to you, Mr. James, if I could. Something that I explored with witnesses this morning was that accepting that evidence about a person's prior life and history is often going to be relevant in multiple ways. So at the moment, it's relevant to good character, but it's often relevant to prospects of rehabilitation, might be relevant very directly on the risk of reoffending, might also illuminate their moral culpability sometimes. How do you see the system operating if the bill is passed, when people will still seek to tender written documents that come from people they know, speaking to their past life? How do we sort of, accepting that the court will have to carefully work out whether it's relevant to something other than just good character, but I'm sure there will be many cases where it is relevant to an assessment of risk, for example, relevant to rehabilitation. How will the system work to somehow minimise the trauma that's caused by these sort of documents going in, while still accepting relevant material that goes to other things other than just good character?
Well, it will be far more objective, and it will not use that loaded language that does harm victim survivors.
Yeah.
Good character is not a neutral resource. It is one of the easiest ways to mobilise support if you are well connected, if you're institutionally legible, professionally supported, and able to gather persuasive referees. This reform removes one of the clearest ways privilege enters sentencing, while leaving in place the genuinely relevant mitigating factors.
Yeah. So, for example, you might get a person charged with an offence, let's say, of street violence. So an adult offending in a violent way against an adult, who then gets a statement from their friends, which is sort of titled, something to do with character or background or something. Their friend in that document talks about what they've known of the person, their impressions of the person, how they've seen the person in like circumstances, so not react violently before. How do we sort of better ensure that documents, when it's referred to in the remarks and all that sort of stuff, is not understood as just relying on the good bloke defence? Because it's going to look and sound pretty similar to what you might have at the moment. but it's just gonna go to something different.
I reject that. I think for a victim survivor to hear those loaded terms, and also if this, or when I should say, this bill passes the Parliament, it will send a message to the community as well, and that's part of the process informing how the process will work out. Now, we shouldn't reach for that language when we're confronted with violent harm and crime.
So do you reject, that the documents will still look pretty similar, or do you reject something else?
I do. I think it'll be far more objective. In fact, I know it will be far more objective because the evidence points to that from the New South Wales Sentencing Council's report.
Okay, that there will be a change in the way these documents are drafted and so forth?
No, but it will establish that good character cannot be mentioned within these written references.
Okay.
Yep.
Yeah, because the sort of scenario that I was posing this morning to people was, so good character will no longer be a standalone mitigating factor. So it won't be something that you can rely to reduce sentence, but a pattern of, behaving in a law-abiding way, a pattern of not committing the offence before, will be relevant to prospects of rehabilitation, prospects of offending, for example. So those things are just so closely related.
I disagree. I don't think they are. I don't think they're that closely related as you're suggesting. I think that they are genuine mitigating factors that should be looked at.
Yeah.
Like the other ones that have been mentioned today, the prospects of rehabilitation, someone's remorse. They're circumstances that genuinely call for to be valued. But I don't accept the proposition that we should preserve a vague and unequal sentencing factor for all offenders, including perpetrators of child sexual abuse, rape and domestic violence, some of the worst crimes that can be committed, because of hypothetical cases. Courts already have more than enough tools to distinguish a serious violent offender.
Yeah, I mean, the reason I say they're closely related, Mr. James, is it's often said the best indicator of future behaviour is past behaviour, right? And good character evidence generally is concerned with the past behaviour bit. Now, when you assess someone's risk of reoffending, and risk assessment's a key part of sentencing, you're looking at past behaviour. So that's the sense in which I say they're closely related. And what I'm really getting at is, do you have any suggestions for the committee that we could recommend in terms of other additional ways that if the bill's passed, the system could minimise trauma? Bearing in mind that much of the evidence that, and I'm not talking about a lot of what you're talking about in terms of completely baseless, mere opinions of reputation and things like that, but a lot of evidence that at the moment goes to character will still go in relation to prospects. Is there ways the system can sort of manage that and reduce trauma in addition to this bill?
Well, again, I state that they're two very different things, because good character is talking to the subjectivity of a reference. The suggestions that you're making here are talking to the objectivity, which sentencing should reflect. They're two completely separate things. That's why I don't think they align in any way.
Yeah, I mean, I think a lot of references that I've seen in the criminal law, they're a mixture of the subjective and the objective. There's not necessarily a dichotomy between the two. I mean, there's a dichotomy, but not in terms of what you actually get.
Can you make that crystal clear? So, for example, if someone said, I've been in the footy team with this guy and he donated to this and he did blah, 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 and they said all of that, but they just didn't say, and I reckon he's a good guy, then you could still have that objective bit then.
Yeah, so you might get references that have all of the objectionable things that you've talked about, Mr. James, but then also have in some valid observations from a behavioural point of view about the person. And it's sort of a mixture. And I think in the future, we're probably going to continue to get a mixture of things, because as much as we might set down these rules about this quite complex thing, the courts are going to have to sort of manage it. And I'm just wondering whether there is additional guidance that could be given on a procedural level to impact this trauma question, because,
I think that guidance is established in the New South Wales Sentencing Council's report.
Yeah, okay.
Can I just ask one last thing? Mr. James, when you set on this incredible campaign that you have, shone such a incredibly important light, and I have no doubt will make systemic change from here on, and you have already across the country. Was it your ambition at the beginning to remove it completely, or were you focused first and initially and foremost on the heinous circumstances that led you to the campaign initially?
The original intent of the campaign was to abolish good character references for child sexual abuse cases, because that was our lived experience. We understood that child sexual abuse offenders often utilise their good character to play out the abuse, as I've stated today. But once there was, in conversations with the Attorney General, when reviews were established, it just started opening up these more and more questions that extend into other crime types, and then in the final report, the New South Wales Sentencing Council obviously found that good character references are arbitrary and have served no real purpose in it by any means. So it's just grown into this next thing. But to answer your question, the original intent was to advocate for this change because of our lived experience.
Thank you.
All right, thank you very much. Questions come to an end. I don't think there are any questions taken on notice. Thanks very much for coming today.
Thank you.